because the co-defendants,
What's up?
she called her job yesterday.
Oh, really? Okay.
Tyler.
Okay.
So I'm not sure what.
Okay. This month.
Had you?
Mm-hmm. Somebody else did.
She did.
Oh, okay. We got to see the new lawyer that's on there.
Right.
All right. Good morning, everyone. We are going to get started. I think I see our court reporter of the day. Can you hear us?
Yes, Judge, thank you.
Great. I will let you know when you need to take stuff down. I think initially we're just going to be calling the calendar to figure out what we're doing, but I promise to be as clear as possible of let's now get on the record or something like that as a signal that it's time for you to go live, okay? If at any time you cannot hear what's going on, wave your arms or do something. Every once in a while, the technology disappoints us, but we'll do our best to keep you connected. All right.
Thank you.
You're welcome. So we have a criminal trial calendar that I am calling this morning. The calendar does not start this morning. It actually starts a week from Monday, the civil trial calendar next week. And then the criminal trial that we do will start on Monday, the 19th. So what we'll do today is figure out which cases are resolving, and that would be today that they resolve, and which cases will be in the queue for trial on the 19th. And I will get an email out to the lawyers as to the order in which we would try the cases that are teed up for trial. Our first position is Brian Hall.
Judge, you fine?
Hello, Ms. Wood.
Good morning, Judge.
Good morning.
I spoke to him about 30 minutes ago. He's driving in Chattanooga and he's in a little bit of traffic. And then when he hits this Pawtucket here on Courthouse, will probably be.
Another hour?
Yes.
Okay,
But
so he's en route.
he is, and I expect the resolution today.
Okay, then we'll hold on that. Kenneth Poole should be on virtually. Mr. Poole, if you could turn your camera and audio on, and I think Mr. Miller is on virtually.
Good morning, good morning.
Good morning, Mr. Poole. Let me add you. There you are. And Mr. Miller, hopefully we'll turn, there we go. He's coming alive. There's Mr. Miller. All right, Mr. Miller, you need to not be driving for about 2 minutes, okay?
I'm sorry, I couldn't hear you.
All right. Well, you're good. I just want to make sure you weren't driving. I don't need to see your ear. I just needed to make sure you weren't driving.
Oh, yes, Your Honor. I'm actually right outside the courtroom. I got caught in some traffic right in front of it.
Yeah, welcome to our life. You would be there for another 30 minutes, so I'll spare you that pain. Why don't you just take a seat? And I will let you and Mr. Poole know that because of a medical leave that Mr. Abate has for this trial calendar, we are not able to reach Mr. Poole's case, which is why I let Mr. Poole appear virtually from Tennessee. And Mr. Miller, I appreciate you trying to get down here, but we've built some kind of fortress around the courthouse, making it really hard to park or drive or do anything practical around the courthouse. So I'm going to excuse Mr. Poole from this trial calendar, and it may be, Mr. Miller, that I work with you and Mr. Abate to see if we need to specially set it, but at a minimum, we will get this case back on a trial calendar this summer.
Okay, thank you, Your Honor.
Mr. Poole, any questions?
No, sir. Thank you so much.
Not a problem. We'll be in touch.
All right.
All right.
Position 3 is Virgil Benjamin. There he is, wearing coveralls again. How you doing today, Mr. Benjamin?
I made it, sir.
You made it. That's good. Is Mr. Abekwe here?
Sir.
All right, if you don't mind, when you and I are done talking, which will happen in about 2 minutes or less, if you'd step outside and try calling him.
Yes, sir.
I'm guessing he's doing his best to get here as well, but we're making it hard for people to get here. But if you could just give me an update, if you do connect with him, because I think we're resolving your case today,
I think so, sir.
but we can't do that without your lawyer.
Yes, sir.
All right, thank you.
Thank you, sir.
Stephen Gomez is in custody. I don't see Ms. Cabrera. She's parking. Okay, she's probably right next to Mr. Miller trying to find a spot. All right, we will come back to Mr. Gomez. And I think, Ms. Dilligard, the way we left it is that Ms. Cabrera needs to spend a few minutes with Mr. Gomez.
Yes.
And Deputy Gordon, Mr. Gomez is up. We have almost all the parts. Javon Jordan has resolved his case, which then gets us to Mr. Gill, who is on virtually. And we said that's okay?
Yes.
We said that's okay. All right. Mr. Gill, if you could unmute, please. But that's not you. Yeah, that is you. I thought you're the one wearing the hat there, but
That might be.
I see a ceiling.
That might be his dad.
Oh,
It's.
oh, that's Dad. Ay, yikes. All right, bye. Let's try that. There we go. Okay. Mr. Gill, can you hear us?
Yes, Your Honor.
Excellent. When Ms. Wood and the prosecutor, who's not here right now, but hopefully will be here soon, and I last spoke about your case, it sounded like there had been a development that moved it more towards non-trial resolution. Ms. Wood, do you have any updates on that?
Yes, Judge. I would ask if Mr. Gill can fall off the call.
Mhm.
He sent me an email yesterday. He wants me to speak with some of his family members as well.
Great.
So I was going to speak to him and then speak to the state and then ask him to log back on for an update.
Got it. We've got multiple Gills on. There's a Ruby and a Jeffrey, who I guess is Dad. So, Mr. Gill, you should drop off the call for a minute. Ms. Wood will call you at the end of the call of this calendar, so it'll be a few minutes as we chart a course for today. And then she's going to give you a call. It sounds like the two of you want to talk, and it may be that she speaks with your parents or your relatives as well. Of course, today is the day if we're sorting this out short of trial. Otherwise, I'm ready to roll on the 19th. We don't have your prosecutor right now. I'm sure she's on her way, but that doesn't mean you and Ms. Wood can't talk, okay?
Okay.
Any questions?
No, sir.
All right, so expect a call from Ms. Wood in a few.
Okay.
All right.
Judge, 88 Clark and Deputy Abadi are coming from Georgia Supreme
Oh,
Court.
that's right. It's swear-in day, so that's probably where Ms. Nix is as well.
Yes.
Of course, we were not able to get Justice LaGrua to do it yesterday. She had a conflict, so they're avoiding being suspended by your boss.
Yeah. The ETA is 9:45.
9:45. They said 9:15 before. All right. Boy, oh boy. All right. Position 7 is Dontavius Wright. Hey, Mr. Carey, how are you, Mr. Johnson? All right, Mr. Johnson, I think you and Ms. Charles and I were on an email chain. Hopefully you were apprised of the fact that the lead detective has a conflict our week of the trial calendar, but your case, Mr. Wright's case, is also on what we call our consolidated trial calendar, which runs that same week, but also 1 week afterwards. And my hope is I don't control exactly the order in which the cases go out on that other calendar, but we put Mr. Wright's case on there, knowing that if we didn't reach it here, maybe we could reach it then, because I know he's anxious for a trial. But I also heard that there were some discussions about maybe resolving the case short of trial.
A lot of discussion.
That's good.
Eddie and Charles and I have had numerous in-depth, hour-long, not longer conversations.
Okay.
And I do think we are very close to reaching a resolution.
Okay.
Well, Your Honor, at the time, and I don't know if you remember, the last time we were here, I asked for a continuance. I just got the case.
I very clearly remember.
And you told me no about 3 times, and finally you were gracious enough to allow it.
So really what I said was yes.
Ultimately, yes, sir.
Okay,
Yes, sir, you did.
that's the answer that counts.
And absolutely. The only thing is that I asked, and when we talked, spoke yesterday, it was the day before, I was outside on a lawnmower trying to cut my grass to beat the rain. And she asked me, I think you asked her if I would consent to a continuance, or my thoughts about it. And I told her, okay, I would. Then I thought about it after the fact and asked if we would do that, considering the state had 2 continuances before I asked for that one that you graciously allowed, ultimately, yes. I asked if the state would agree to consent to a bond meanwhile. And it was late in the day, and I'd already told her that I would consent prior to that, and that was my fault. However, there is an outstanding emergency motion for bond I filed back in February that I haven't heard anything about. My client's been stabbed twice. And
I'm happy when we get Ms. Charles here, we can bring Mr. Wright out and we can talk about bond.
she's not gonna be here today. She did tell me she's not. I think she's had a flight out today.
Okay,
So she's.
well then we can't do a bond hearing today.
Was there anyone else that can do it? Or if I can get a definitive answer on potential consent for bond, and then that may make it easier for you, to make your decision.
So let me ask this question. The negotiations that you've been having with Ms. Charles, are they trending towards a probation sentence?
Well, it's trending towards a, credit for time served with probation.
As in, the plea results in being released from jail at the time of the plea?
If the state agrees. And obviously, if the honor agrees, ultimately, but, yes, it's a murder case.
I understand what it is.
I don't know how deep you want me to get into it.
No, what I want you to do is not be cagey. If Ms. Charles were here and I were to ask her, is the state offering time served right now? What would she say?
She doesn't know. She put in a request for it and she hasn't gotten word back. I think she needs to talk to the powers that be.
Well, one of the powers that.
She's actually considering it. She went from way extreme to understanding and agreeing that, hey, this makes sense, but she hasn't gotten the go ahead yet. I think that's what we're waiting on. And she wanted to talk to one more witness, which we tried to do yesterday, but her investigator was not available to be privy to that phone call. So we couldn't do that. And after that, I don't know what the state's ultimate answer is going to be, but she's considering that absolutely.
Okay, well, one of the powers that be just walked in. Mr. Abate, welcome back. Are you now officially a member of the Supreme Court Bar? Wow, you look a little different. All right, there's a little shine to you.
I see. I walked real quick.
Yeah, that's the shine. Okay. It's faster walking right now than drive. It's probably a 20-minute drive, even though that place is 3 blocks away.
At this time, the answer would be no. In my speaking with Charles last night and this morning, as relates to time served plea. I know
Okay.
we are in active negotiations.
Okay.
But time served so far not up.
Okay, I want to be clear. I don't get in the middle of negotiations. I just didn't want to be hearing only one half of the conversation, the half that obviously is hoping for a time served resolution.
Well, I'm hoping for no problems, but that's, this is.
You know what? Hope springs eternal. What we can do, Mr. Johnson, is figure out when Ms. Charles will be back. The state is entitled to notice that we'd be having a bond hearing so that they can get victim family members plugged in. If the victim family members want to be, you know this well, they have an absolute right to be involved with something like a bond hearing. So I'll bring Mr. Wright out in a little bit and let him know what's going on. But I will tell you that if there is a high likelihood of being able to try this case in 2 weeks, if it's not resolved, there's a very low likelihood of granting bond. But that's not a surprise to you. It may be a surprise to Mr. Wright, but we'll figure out a date and time to have that bond hearing. We don't need to wait until the date that it could be tried, but that's right on the horizon.
And 2 things. First, I'm not sure, I'm not absolutely clear if we have a no, a yes or no to the consent bond. That was pending as well from the state.
It's a no.
Okay, all right. Secondly, Your Honor, again, my client vehemently denies these charges. He's been in for, and I know this 2 weeks is not far. I do understand the grand scheme of things, but he's been stabbed twice.
I've heard all that, and if we're gonna talk about it more, we're gonna get Mr. Wright out here, so we'll do that. So if you take a seat, I know what we're gonna do when we circle back to this case. We'll bring Mr. Wright out and at least talk to him about where we are procedurally.
Yes, sir, and I'd like to speak to him briefly while we.
Okay, well, that's really, I don't know that the deputies have the capacity. Okay, there you go.
Thank you, Your Honor.
All right, Mr. Jintao is our next position.
Judge, I don't see you. But I do expect him.
You're expecting him, okay. He may be in the same line. Mr. Estrada is here. Is your lawyer here? She's making her way here. All right, Ms. Dilligard, do you expect this to resolve?
I tried reaching out to counsel yesterday, both via phone and email, but I hadn't heard back, so I'm not sure.
Okay, well, hopefully she shows up and we'll figure out what's going on. Mr. Stokes, we need to have an immunity hearing. Mr. Stevens, we had to reset at defense request. Mr. Leak, we had to continue, and I will modify his bond. Mr. Okoro. I guess if you could reach out to Mr. King and Ms. Kim, they may be thinking they don't need to be here till 2 because we've got a hearing this afternoon, and I'm all right with that, but it would be great if they checked in.
Okay.
In opposition 14, I just got an email from the attorney who is in another county, but I don't know if he needs to come, actually.
Well, let's see if his client shows up.
Well, yeah, it's under judicial hold.
Okay. E. Carlos Wilkins. All right, he does not need to show up. You'll let him know. Tariq Thomas. Hey, Mr. Thomas. I'm all right. Mr. Ben Shida, do you know where he is? Okay, he's probably trying to get in the same way that these other lawyers are trying to get in. Why don't you step outside and see what his ETA is? Thank you. Lauren Scott.
I'm going to try to get in touch with her.
Okay, when did you last speak with Ms. Scott?
The end of last week.
Okay, recently.
Yes.
Great. Are you sitting on the ground?
No, I'm curious.
Okay, you want to see Mr. Dennis?
I'm gonna have him brought out.
Okay, got it.
So very healthy.
No, he's fit. That's great. Catch your squat just in case. Anthony Johnson. Hey, Mr. Johnson. I'm all right. Do we have, what is our update with Mr. Johnson?
This is the one, I don't think it's gonna resolve today, Judge. I'm still talking to Ms. Dilligard. I would ask that Mr. Johnson stick around.
I would ask that too.
Yes, so I'm gonna keep talking to both parties, but I don't think we're gonna resolve it today.
Okay, all right. Take a seat, Mr. Johnson. We will talk again soon. Please don't leave till you and I talk one more time. Mr. Drabeck resolved his case. Shamir Ferguson is here.
Judge, you could just hold.
Okay.
I've already spoken to Ms. Charles this morning, and I'm gonna go to Mr. Ferguson after the call.
Okay, all right, Mr. Ferguson. Ms. Wood's going to talk with you, and then we'll talk one more time. Kenneth Jones.
This should be okay today, Judge.
Great. Cameron Hill is here.
Also a plea today, Judge. I just need to iron out a couple of details.
All right. Jason Nickerson.
I spoke to him yesterday, so I do expect him today, Judge.
All right. We'll hold for him. And then we have our supplemental calendar. Germonta Rogers. I saw Mr. Francis here. Hey, Mr. Francis. Good morning. How are you? I'm all right. I think you've heard we had a little hiccup in this case, not concerning your client, but because of the two speedies that were filed, yours and the former Ms. Hills, I was set to do this our trial week. We don't have a lot of time left. These are young men, they're stuck in custody. But Ms. Hill determined yesterday that she had a conflict and had to step off. And you're the replacement. Fantastic. Nice to meet you. You are?
I am Nelson Rhodes.
Mr. Rhodes. I don't think we met before. I saw your name in an email. Welcome aboard. We'll see you for trial. Kidding. Well, let me ask this first. Deputy Gordon, are Mr. Rogers, Mr. Mender, and Mr. Horn here yet? Not yet. Juveniles often come later. Mr. Rhodes, tell me a little bit about your role. Are you with the state public defender?
I am.
Okay, and
Still working conflict capacity.
great. Do you typically work with juveniles, or this will be a new role?
My first case.
Okay. Ms. Hill had filed 2 motions of impact so far. One was the speedy demand. It was timely and valid, and so that clock is ticking. She also filed an immunity motion. I'm going to give you a thumb drive that has this case on it. It's the MARTA footage that shows this man being shot. I can't remember if it's your client or Mr. Dennis, Mr. Francis's, but I think it's yours, who's got the gun and shoots the guy. And I'd ask you to watch that and then let me know if you want to persist in the immunity motion. You're certainly entitled to do that, but it's a fresh set of eyes and legal acumen. And you may watch that video and say, we're going to have the hearing, but the outcome is pretty clear. And so there's this speedy filed. Let's focus on going to trial. And really what I'll need to know from you, not today, but after you've had a chance to wrap your arms around the case, although it is pretty much this video is the state's case and whatever defense you come up with, when you think you'd be ready to go to trial, assuming you leave your speedy in place. But even if you don't, Mr. Francis has filed a speedy on behalf of his client, and that's going to drag all 3 defendants along. And so I need to balance the urgency of the speedy with your absolute right to get up to speed, if you will, on the case. I don't think it's a sprawling case in terms of the facts and circumstances and evidence. It's pretty much this surveillance video that captures it. But I don't mean to suggest that you should be ready tomorrow because of that. But we'll need to be having a little bit of back and forth over the next few days as you give me your best estimate of when you'd be ready to go. Or you may look at it and say, this isn't a case I'm going to try. I'm going to be working with the prosecutor to figure something out.
From my understanding, speaking with Ms. Hill beforehand, she's also sent me the video.
Oh, have you seen it?
I have not yet.
Okay.
However, the basis for the immunity motion, from what I understand, is to really attack the armed robbery charge based on the possession of the phone that was allegedly taken. And perhaps this would, be better fleshed out in the immunity motion hearing next Thursday, but apparently the phone that is in contention here belonged to Mr. Horn. So with that.
So he's basically taking his property back.
Yes.
Okay. Well, I don't know about the immunity part of that, though. It may be that there is insufficient evidence. We don't need to have too much of a back and forth. But again, having watched the video a few times, it may well be that there's a directed verdict as to the armed robbery. But if you haven't watched the video, you will see after the phone is no longer in the gentleman's hands who was shot, and whatever threat there may have been from a guy sitting on a bench, someone shoots him in the leg. This unarmed guy who had a phone. And so that's the part, I'm assuming that's the immunity part. I don't know. Like the shooting is justified or it's not justified. So that's where I was having a bit of a disconnect with the immunity motion. You've helped me understand that maybe it fleshes out a record, but We'll have to work through that.
I'll still say that this is my first SB 440 case, but I think my understanding, at least from what Wanda was telling me, was that if the armed robbery were to fall away,
Mhm.
then this would go to juvenile.
Ah, okay. Interesting. And you and Mr. Francis and Ms. Cabrera should talk about that. That may be right. I hadn't thought through that. What I don't see is how an immunity motion makes an armed robbery charge go away. But you should watch the video and we'll figure out what we're going to do to move forward. I'm going to need you to stay until Mr. Horn gets here so you guys can meet. And of course, we can all talk about scheduling, but I don't expect you to be ready for trial on this calendar unless you want to be ready for trial.
I
Okay.
will say as well, I'm doing Judge Barwick's courtroom as well for the moment, but I'll try to be back as soon as possible.
What are you doing in Judge Barwick's courtroom?
It's a final plea calendar, but I don't anticipate it will actually be resolved. It'll be moved to a trial calendar.
One case? Okay. And it's what's up now or it's on a 57 position calendar?
I don't know.
Okay. Well, it's just right down the hall. So if you want to go to that, then we know where to find you and you can just keep us posted. And we'll certainly let you know once Mr. Horn gets here. Okay. Thanks. Nice meeting you. But Mr. Francis, you represent Mr. Rogers. I assume you're ready to go. You don't have the immunity. You have the speedy, but not the immunity. Okay. And you have some leave over the summer, and so we need to.
I'm ready, Judge. Whatever you want me to have, we'll work it out.
Okay, but I don't want to have the trial during your leave.
No, I know I filed the speed.
Right.
And so I'm prepared to try the case and restructure.
Okay, all right. I want to be clear. I won't purposefully put it during your leave. Our trial calendars are already set, and I think Ms. Nelson had flagged the fact that one of our trial calendars, Mr. Bass, hold on one sec. One of our trial calendars was smack in the middle of your leave, and so I was trying to avoid that. But
And I'll say this, Judge, I filed those leaves well in advance, just in case we take a long vacation or something.
Okay.
Not this year.
Okay, so you're protecting it, but it sounds like it's flexible. All right, good to know.
There's some recent case law from the Supreme Court. Our leaves don't trump kind of about speed.
Okay,
So I don't want to run up into those problems.
okay.
So
All right, well, we have some speedy trial experts sitting here in court, so.
actually, effectively, we're waiting.
Right. Okay. Well, I will do my best to avoid hitting that time, but our calendars are sort of where they are. And Ms. Cabrera, good morning.
Hello, Judge. I think I'm the next in the lineup.
Yes, because we had talked about Rogers. None of the juveniles are here yet, but they're en route. And so Mr. Mender's not here. I know you and Ms. Dilligard, we're going to be talking some more about that. And our schedule took a little bit of a hit when Ms. Hill rolled off, representing Mr. Horn. But you got to hear Mr. Rhodes. He's raring to go, and I don't need to get him the video because he's already got it. He wants to talk with Mr. Horn, and then we just need to figure out when we can try the case and how many will be going to trial. If it's going to be all three or a subset, because things are working out. But we'll see. Okay. And I don't have an answer yet on the bond. I haven't forgotten that. Just we've been in court, but I will certainly address that.
I definitely told one, because we had two situations exactly the same.
Uh-huh.
So I definitely told one family, be patient.
Right.
So
That was probably Mr. Williams's family where there were 110 people here. Mr. Mender, it was just mom, and I think she understood what we were working through. Okay. Yeah, I remember Mr. Williams's mom. Okay. And then lastly, Mr. Bass, Bratton Dennis we added him to the supplemental trial calendar. You have been ready, always. And so I thought, great, if for whatever reason other cases fall through, you remain ready, but we ran into an unexpected but important medical leave for Mr. Abate. And so we won't be able to reach Mr. Dennis's case on my 1 week May trial calendar. I will explain that to Mr. Dennis. But
Eager to get out of custody, obviously. I'm ready. If you want to bring it in Monday, I'm ready.
okay.
Can we specially set
It's a fair question. Don't know. I'll have to look at my schedule. But your willingness to be ready is a good sign for making me motivated to do that, because I have specially set things and then something comes up for the defense attorney and that we got undercut.
absent divine intervention? I'll be ready to let it.
That's the sense I'm getting, and I hope there's no divine intervention. So I will engage with Mr. Dennis in a minute, with you and Mr. Abate, but we won't be able to do it this trial week.
When is the next?
June? I mean, it's just like, well, this is May, so we get to June.
I can't be anxious.
Okay, clearly people are anxious. I get that. And we are working through the cases as best we can.
He's undergoing the same problems in custody. I heard of somebody getting stabbed twice. He's fighting it off.
Okay.
Not a happy place, as we all know.
Yep. That's Mr. Gibson? Okay, great. So we'll do his final disposition?
Yes.
Great, you don't do it right away, but they'll want that. That's it for the trial calendar. Maybe some people came in late. Anyone not hear their name called?
We have one more that's.
Who, way in the, okay, we'll start with red. Yes, sir. Brian Hall, position 1. Excellent. Ms. Wood, he's here. All right, Mr. Hall, I've been told you're working your case out today. We'll see what happens. All right, in the way back, sir.
Also my judge.
I didn't hear the last name.
Nickerson, who's the left.
Oh, right, 22, okay. I heard your case may be working out today. Ms. Wood's gonna talk with you, okay? All right, and then we have 2 attorneys.
How you doing, Judge?
I'm well, how are you?
All right, tournament cheating position 15, Mr. Trump.
Yes.
You got it. I think this is like. Oh, we have that one too. He's number 15.
Okay. Yes, Mr. Thomas is here, and I had your case down as we're not sure whether it's being resolved or not. Ms. Clark is being sworn in at the Supreme Court and is working her way back here. You'll see prosecutors trickling in as they get blessed over there. So I guess we need to wait for Ms. Clark, but I'm happy to hear from you what your preliminary announcement is.
From the last offer that we got, we still stand on not guilty, so I don't know if that has changed, but if not, then we're still in trouble.
Okay, well, let's wait for Ms. Clark to get here, see if she has anything different to say to you. And if the answer is no, then I will add Mr. Thomas to our short list of cases that are ready for the week of the 19th.
And Your Honor, also, I am on the Wheaton County's trial calendar for the 19th. I have 5 that I'm ready for, and they're older in nature. So today I'll file my conflict, but just to let the court know.
Okay, I appreciate knowing that, because if they're older, that's where you're gonna be. I wish it was based on the booking number and not the indictment number, but here we are. All right, let me get that down. So the conflict is in the docket now?
No, I didn't know when this trial calendar was, so I'll file it today.
Okay.
Ms. Clark said she was going to stop at Judge Ingram first because she had a pre-trial conference.
Okay, thank you. All right, so you guys can take a seat. Yes, sir.
Yeah, I represent Anton that I was told was on the calendar today we had a consent bond that we were trying to get to the, it was paid to a Plea case.
So we have several attorneys here for Mr. Bratton, and I asked my team to just hold for Mr. Bratton to get here and all his lawyers so we could figure out who's in charge and what we're doing.
I have the answer to that. First, I do have a proposed consent, proposed order for me, my withdrawal. He has hired, Mr. Kendall.
Mr. Kendall.
So, I saw an entry, but it wasn't entry in substitution, so I'm here at the advance of caution. But if it's okay with Mr. Kendall, I'd like to withdraw from the case. But before you sign that, I do have a consent order to reinstate bond, if the court will consider it. So that way, Mr. Britton can go ahead and be released. So the state is okay with reinstating the bond. So I have both of those to present to you.
So I'm gonna unpackage all this. I got an email forwarded to me a few days ago. I think it was last week, early this week, where Mr. Jenkins from the DA's office had said, we consent. He'd been working with Mr. Kendall. This was after Mr. Kendall had filed his entry, but not substitution. And I thought, that's interesting. I'm not going to do it without having Mr. Bratton here and actual back and forth with the two sides. And then I looked into the docket and saw that Mr. Bratton is a man of great means and has multiple lawyers, all of whom are retained. And so we were going to have to talk more about how it was he didn't make it to court. So we will have that hearing. It'll be with Mr. Kendall. I will gladly sign your order of withdrawal. Mr. Kendall has been actively advocating on behalf of Mr. Bratton over the last week or so. You don't need to stick around, Mr. Chadha, for the reinstating of the bond.
Any other?
Yes.
Thank you.
You gonna get that this morning, Jim?
Yes, sir. Assuming Mr. Bratton is here. He's here. Excellent. Ms. Dilligard, I didn't let you pipe up all the way on this. Are you the one who'll be handling the discussion we have, or do we need to get Mr. Jenkins here?
I believe I can do that.
Okay, great.
Since I'm gonna be gone, I'm gonna be just downstairs, Judge Farmer, I have a bond hearing. If I'm needed back, I can come back, but just to give the court, I told the state this already. I was the attorney at first appearance. The paperwork Mercury shows me as the attorney. I never got a notice. The bonding company, I've been in touch with them. I have an email that I provided to the state. They also never got noticed. And with the way things have been with the mail, and Fulton County Clerk's Office, not blaming anyway. My understanding, Mr. Anton Byrne also never received notice. He has moved, the address is correct in the system now, but that was the basis as to why he did not show up, not because he wasn't the run. But that's just my 2 cents, but.
Got it.
Can I be excused now?
Yes, sir. Thanks for being here.
Thank you.
Mr. Johnson.
Real quick, one thing I omitted to say earlier, I filed a notice of leave and account reminded leave vouchers back in February. And the case was initially on to June 12th trial count. All right, and then it was subsequently moved to the consolidated, the 19th or the 26th.
It remains on the June calendar.
Okay.
It's in both places. You shared with me that you and your client were anxious to get it tried. And so I thought, let's create as many opportunities for trial as possible. So if it was on the June calendar, it should still be there, but let me look. I don't want to mislead you on that. Was there something were you asking, could it be added to the June, or you have leave for the June calendar?
No, I leave for the May calendar. But hopefully, again, this may be moving on us, because we're very close to a resolution in this, to the plea. So hopefully, and in fact, in our calendar, our cruise schedule, and.
I don't want you to miss the cruise.
It was already.
That would make me unpopular in your household.
Well, it might be too late for that. To be honest, not just you, me too. But so if it was out, it was moved. But at this point, if it's gonna be moved to my leave is May 27th through June 10th. But we're continuing it to the May 26th calendar. My leave starts the very next day.
Right, and so it wouldn't make sense to, but the two cases I have on the consolidated calendar are yours and Mr. Mosley. Got it. Okay, so so Mr. Wright's case is not on our June calendar right now. I'm looking and it's not there. It doesn't mean we can't add it as a supplement. When do you get back from your big cruise?
The 10th.
Okay, so that calendar is called on the 12th, but the actual trial isn't until later in June. So you may have work conflicts, but it doesn't sound like you will have love boat conflicts.
Correct.
Okay, got it. Yeah, the actual criminal trial calendar that when we'd be trying cases is June 23rd. So that would be, you'd be tanned, you might have a nice straw hat, but you won't be on the boat. Okay. Well, that's where we are right now. So the only way it would work for you on the consolidated calendar would be if Mr. Wright's case went the first week. The consolidated calendar is the week of the 19th.
What the state's investigator is not going to be available that day, which is the.
Oh, right. Which is why we're not trying it, right?
Which is why we're here.
We're not trying, because it's on my calendar. And I was all ready to go. And then Ms. Charles said, the lead investigator is not available. So that's all the more incentive for the two sides to get as close together as they can. Maybe it's a non-negotiated plea, maybe it's negotiated. I am fine taking a plea next week. I'll be in a civil trial, but we will do it over the lunch break or start trial at 10 one morning and take the plea at 9, consistent with your schedule and Ms. Charles's, if you get there. It sounds like there's a gap and you're right now negotiating with a ghost because Ms. Charles is busy doing something else. But I know she's been very responsive. She is both those things. And I know she's focused on doing the right thing with this case to the victim's family, but to your client and what's the evidence. And so she'll keep working on that. I don't know when she's back, but she didn't have a conflict for the trial calendar. It was the investigator. So that says to me, she'll be back soon and you two should continue your conversations.
The last thing what we're talking about is to come to an agreement. It's also potentially a incentive for the court to consider a bond if it's going to be June instead of 2 weeks.
Okay. So I hear you on all that. I will engage with Mr. Wright in a minute. I'm going to let the lawyers talk with their clients for a little bit before I come back out. But that'll be one of the first things we do is to bring Mr. Wright out. And what I think I'll do is send an email to Ms. Charles, copying you, of course, and Ms. Nelson, saying we need to see if this is working out. And if it's not, we need to have a bond hearing. And she will present the state's perspective. It may not be a consent bond, and she may say no bond, she may say high bond, whatever, but I'm not disagreeing that it's time to have a conversation about that. It just needs to be I'm going to put it in quotes, notice calendar. I don't think we need 10 days, but the state needs that opportunity to alert the victim's family that there's going to be a discussion that could result in your client being released. So if you'll stick around, we'll get Mr. Wright out immediately after the break and engage on that, and then we'll see where it goes.
Thank you.
You're welcome. All right. Any update on Mr. Jintao?
No, Judge, I'm involved in,
And you need to talk with Mr. Gill. I need to give you some time to interact with folks. So why don't we do this? I'm going to take a few minutes off the bench. When I come back, if we could start with Mr. Bratton. So we'll bring him out and talk about the consent bond. And then we could bring Mr. Wright out and Mr. Dennis out so that they can express their frustration. I'll let them know what's going on. And that way, Mr. Bass, you'll be free to attend to other business. And same with Mr. Johnson, who'll be able to move on to other things. We'll touch those two cases and then we'll pick up with pleas or whatever else is going, or bench warrants or whatever else is going on. All right. And Ms. Clark is here. If you would speak with Mr. Ben Shida during this break, if you'd start with that, because he was saying that Mr. Thomas is probably going to be a trial unless something has changed.
okay.
That's fine. I just need to know who goes on that list. Okay? Anyone else have something we need to talk about before we take a quick break? Oh, any update on the whereabouts of your lawyer? Did you have a chance to call her or you haven't stepped out yet? No, not yet. Okay, during the break, reach out to her, please. Thank you. All right, I will mute things here.
Audio, please.
Sorry about that. Audio should be back on. We didn't say anything super important, but
Thank you,
it's
Judge.
on. You're welcome. My bad. All right. So maybe no Ms. Scott. We need Ms. Wood to talk about Mr. Johnson. That's Ms. Wood, Ms. Wood. Okay, I think that's who we were waiting on. So why don't we bring Mr. Bratton out, please?
Sure.
He can come to the podium. And this is not a case that's working out anytime soon?
Yeah, and I just got in, as you know.
I do know, but I know you're a senior counsel as well.
Yeah, and I am going to talk to the state and see if we can resolve this and get it off your calendar.
All right.
This is Bratton.
Yes, ma'am, Bratton.
Is the Chatham Kendall?
He's right here.
Okay.
Yep. Yeah, we had Mr. Chada here and he withdrew. Mr. Kendall is ready to roll. What's the date he missed?
I think it's December 3rd, Your Honor, 2024.
24? Okay,
That's my understanding. Is that Johnson?
got it.
It's my understanding, Judge, that was an arraignment calendar.
Okay, I'm just looking for a few documents and then we'll get started.
Second row. Let's see, yeah, second row.
What's your zip code?
30204.
That's correct, 60 Roundtree.
Yes, sir. All right. Let's go on the record, please. This is 24 SC 005020, State versus Bratton. Mr. Bratton is here in court with his lawyer, Mr. Kendall. We have Ms. Dilligard for the state. And Mr. Bratton, I'm Judge McBurney. We didn't get to meet in December because you weren't here for your arraignment. You've cycled through a couple lawyers. Mr. Chada was here a little earlier today, but gave me a proposed order so that he could withdraw. And Mr. Kendall, who filed an entry a week or so ago, has been, maybe even earlier than that, has been working pretty hard on your behalf. We're going to talk about why you missed court today. And depending on what I learn, I will reinstate your bond. If not, we'll keep you where you are till we resolve your case. So, Mr. Kendall, tell me your understanding as to why Mr. Bratton wasn't here for the plea and arraignment calendar in December of last year.
Yeah, and it's my understanding it possibly was an address problem with on our part, with the clerk's office. And that I haven't seen it, whether or not in the docket, whether or not it was a return from that address, but at some point in time between the initial arrest and bond, that Mr. Brogdon did change addresses. Yes.
Okay.
Okay. I think prior counsel did represent him, from my understanding, at his initial appearance and obtain a bond for him. I would not imagine that the clerk's office, I mean, sometimes on that, they send them to the council, sometimes they don't, because I've had it done to me. So, but the bonding company said they normally get notice and they never got any notice, and they willing to go back on the bond. So, that's I'm sure you've been around here long enough to know that that's not always the case with bonding companies when somebody missed. But they said they had no notice of it either. I have Mr. Brogdon's wife here in court.
There are a lot of people out there. Who are we talking about?
This is his wife,
Great. Thank you for being here.
and his employer is a business partner of mine, so I know everybody's concerned that he's gonna be here.
Okay. Your business partner does what?
A National Limousine, which is a bus and limousine service out at the airport.
Familiar. That's the one that drives that shuttle that's always late between the international terminal and domestic terminal.
I have to explain that to you, Judge.
Yeah, we don't have enough time for you to justify why they still have the contract, but I'll let you fight that with the city council. Is he one of the slow drivers?
No, yeah, he owns the company. He owns the company.
This gentleman owns the company?
No, he works for the gentleman that owns the
I
company.
understand. Are you one of the drivers of the slow buses?
Oh, sir, I'm a mechanic.
You're a mechanic. All right.
He said you put the filters on that.
Yeah, you're right. He doesn't know why the engines keep breaking down. Okay, got it. How long have you been at this company?
I've been with the company since 2014, off and on, but lately I've been 2 years,
Okay,
over 2 years.
got it. All right, back to you, Mr. Kendall.
His uncle owns the company, yeah.
Okay,
So, and everybody has been trying to get him out, getting back to where I've heard nothing but good things about him. We're gonna resolve this case one way or another.
okay. And I want to be clear, the charges are not alarming. It seems work outable. So I'm focused more on ensuring that Mr. Bratton makes it back when we next have court. I'd like to treat today as an arraignment day as well. If you're willing to waive arraignment, we've got a form you can fill out, and that'll you don't need to do it right now. Let's finish our conversation, then you can do that. Mr. Bratton, tell me what your address was in December of last year.
60 Roundtree Road,
Okay,
Riverdale, Georgia.
Riverdale?
Yes, sir.
Okay. Did you ever live at 1212 James Jackson Parkway?
Yes, sir.
You were arrested on this way back in February of 23. Was that your address back then, the James Jackson Parkway?
Yes, sir.
Okay. And then your family moved to Riverdale?
Yes, we actually bought a house out there.
Great, because they pay you so well at this slow limo place. Excellent. Good to know where the money's going. The notice that was sent for you to be here in court was sent to that James Jackson Parkway, and it was returned. So even if you had done address forwarding, it would not have gone to you. There's nothing in the docket that the bonding company got notice. So it looks like you didn't know to be here in court. That's what I'm seeing from the records we have from the clerk of court. Ms. Dilligard, what is the state's view about reinstating the bond in this case? Okay. Then what I will do, Mr. Kendall, in exchange for you filling out the waiver of arraignment form, is set aside the bench warrant that will reinstate the bond. Sounds like the bonding company's still on it. Let me tell you what the system says right now about an address, because we may need to update that in case. Nope, it's good. It's exactly what you said. So going forward, you're going to hear from your lawyer because he'll get notice. So make sure you've got his contact info. In theory, you'll hear from the bonding company, but we'll also be mailing notices to your Riverdale address. I don't expect that you're going to have a court date anytime soon. What's going to happen once Mr. Kendall gets us that waiver form, which he'll do before he leaves today, is I'll enter a scheduling order that gives the state a deadline to get discovery to your lawyer, whatever the police reports are, or if there's body cam, whatever it is. They'll get all that to Mr. Kendall. He'll look over it. That'll give him a sense of weak case or strong case for the state. And also, wait a minute, they made my client talk to them without Mirandizing him. He might want to file a motion, and then we might have a motions hearing. You'd be here for the motions hearing, and then you would be here for what we call final plea, which is the deadline for you to resolve a case where you have the ability to withdraw your plea if you don't like the sentence you get. I don't know that that'll even be the situation. It may be well before then. Mr. Kendall will negotiate something on your behalf that you're ready to do, and there's no need to wait that far out because these charges are going to be hanging over your head until the case gets resolved. And it could be the state dismisses the case. I don't mean to suggest that the outcome is always guilty plea or trial. That's a conversation your lawyer will have with the prosecutor.
Okay.
Any questions about any of that?
No, sir.
Let me check one more thing, and that's the conditions of your bond to make sure you remember them since you got your bond 2 years and 3 months ago. Maybe a little rusty in your mind. The case has not moved at lightning speed. You are supposed to stay away from a gentleman whose last name is Diallo and an address on Cleveland Avenue. Sounds like maybe you lived or had some belongings there at one point because the bond allowed your wife to go get belongings from some address on Cleveland Avenue. Okay, so you'll stay away from that address?
Sure.
All right, and whoever Mr. Diallo, I think it's a Mr. Diallo, stay away from that person?
Yes, sir.
Done. Mr. Kendall, anything else?
Nothing else, Judge. Just appreciate you.
No, I appreciate your patience and persistence. If you'd fill out the waiver form, once you've done that, you can leave it with Deputy Gordon and you are free to go. Mr. Bratton, you ought to be released today. Paperwork doesn't always move that quickly, but I'll do the set aside today. If you are in this time tomorrow, have your family call Mr. Kendall. He will reach out to me. I will reach out to the jail. Tomorrow will be the latest you get released, assuming you have no other holds. I don't know you. If Clayton County is waiting to get you, you actually go to Clayton County.
I didn't have any.
Okay, well, good. Well, I hope you're reunited with your family. How long have you been stuck in there?
2 weeks actually today.
All right, it's a long time.
Yes, sir.
Mr. Kendall, anything else on behalf of your client?
No, Your Honor, that'll be it.
Ms. Dilligard? All right, that's it. Ms. Bratton, thank you for being here. All right, well, thank your lawyer, man. He's the one twisting arms.
Anybody next up?
Yes, Mr. Dennis.
Mr. Dennis?
Dennis's last name, yep. And then Mr. Wright. Were you asking for the no pros? Never hurts. The worst he's gonna say is not today. Hope springs eternal.
I'm old enough to remember Jesse Jackson version.
Mr. Dennis, to the podium, please. Morning.
Good morning.
I'm here to give you an update on your case. Have you two spoken already? I will still give them the update. I wasn't sure if you were able to get back there. Okay. Mr. Bass has been here since the call of the calendar. And Mr. Dennis, I had added your case to our May trial calendar in the off chance we'd be able to get to it because Mr. Bass reminds me every time I see him that you're anxious to get into court for the trial of your case. It doesn't look like we will be able to reach your case this trial calendar. It's just 1 week. But Mr. Bass has told me that he will be ready to try this case any day, anytime. I can create that opening. So I will add your case to our consolidated trial calendar, which is a bonus 2 weeks every month when we have another judge in here trying to move cases along. And we can roll your case onto our next calendar as well. But I want to let you know that we wouldn't be reaching this case. It was hopeful when I added it as a supplement, but it falls in line behind 22 other positions. And there are enough of the other 22 that are going to go to trial that we don't get to yours. But I wanted to tell you that. You hear it from Mr. Bass, but you might as well hear it from me because I'm the one managing the docket. Okay?
A couple of things, if I could, Judge. On the May 19th calendar for Mr. Dennis's understanding, the prosecutor who's handling the case has filed a medical leave of absence, which is why we're unable to go on the May 19th because the prosecutor won't be here. He's filed a medical leave.
So there are two reasons. That's one. I didn't mention that, but that, hey, face this way. But we also likely wouldn't get to it anyway. Mr. Dennis's case was the add-on where if the 22 position trial calendar completely collapsed, meaning everything resolved, then at your request, appropriate request, let's get it on here, because the normal cycle would be to have bounced it from the last calendar, skip over one, because we'd already built this calendar, to the next one, which is June. But we'll just add this to the June calendar, and I'll put it on the available consolidated trial calendars as well.
I had also made a request that it be specially set.
You did make that request. I'll look at my calendar to see where we could do a special setting. And that, of course, would move it to the top of a calendar. So I'll see if we can fit that in as well. Mr. Dennis knows well, because he's at a jail full of people, that there are folks who've been in longer than Mr. Dennis, and generally the older case goes first. And that's how I try to work it as well. We'll do what we can, but your lawyer, Mr. Dennis, has made it painfully clear that he is ready, willing, and able to try it at nights, if that's when we could do it. So we're not waiting on him. We're waiting for space in my criminal trial calendars where you're not cutting in line of folks who've been in longer than you, so we can try your case. All right?
All right. Yes, cool.
Let's bring, you're welcome. Let's Mr. Wright out, please.
Yes, sir. On the phone, since you're like gonna keep switching back.
He's not gonna Thank you, Judge.
You're welcome, Mr. Bass. Thank you as always.
I gotta bring this note, cover down. Got rid of the first class, so we come back. I didn't like case here.
Yeah, I think he wants to talk with you. Do you want to stick around, or let him know you will come see him? You can't go back there right now. We don't have the person power.
I'll go to jail.
Okay, we'll let him know.
Right.
Mr. Johnson, you can come on up.
Let's switch your mouth. Turn the picture.
All right, Mr. Wright, good morning, sir. I wanted to give you an update as to where we are. You are on our trial calendar. You're on 2 trial calendars. Mr. Johnson has been advocating hard to get you tried. Of course, we had a trial date and everyone else was ready to go, but you switched lawyers. And so I couldn't try your case when I was ready to try your case. But here we are. And the week that I have available to try you, the lead investigator is not available. So that's not a time we can do it. But I also added your case because Mr. Johnson has made clear that he is anxious to get this resolved. I keep saying try. Mr. Johnson has also been negotiating pretty feverishly with the prosecutor, helping her to understand that it may not be the kind of case it looks on paper. And they've been, it sounds like moving in a direction that's favorable for you, but I don't get in the middle of the negotiations. I don't guide those. I don't control those, anything like that. But if there is something negotiated, the lawyers can bring that to me. The 2-week trial calendar overlaps with mine one of the weeks when that investigator's not available, but that second week is a conflict for your lawyer. So he has asked several things. One, when are we going to have a bond hearing? And we're going to set that down. We need to get the prosecutor back here so that the state can give notice to the victim's family. They have a right to be present virtually or in person if there's a bond hearing. And I've told Mr. Johnson, if at any point he and Ms. Charles, that's the name of the prosecutor, if they reach a point where they think it's resolvable through a plea, and it could be a non-negotiated plea, the state is here and you're here, but it's close enough that you and your lawyer are comfortable with that gap, I'll stop what I'm doing and we'll do that plea. The part that's going to take a little moving things around would be to find that block of time for a trial, which is everyone's last resort. Because you don't get to negotiate after trial if it doesn't go well for you. Murder is murder, life is life. Of course, if you're found not guilty, then you're not having to negotiate anything either. You, assuming you have no other business, you just go home. But they're big dice to roll when it's a murder trial. And Mr. Johnson knows that well. I know he's been talking to you about that. But I wanted to share with you the realities of where we are with scheduling. I know I'll see you soon for a bond hearing. Sounds like instead of a bond hearing, it might be that I see you soon to talk about either a negotiated plea or a non-negotiated plea. But if those negotiations don't bear fruit, we'll still have that bond hearing. If that bond hearing doesn't go well for you, we still are teeing you up for one of the next available trial spots. Mr. Johnson has said he's ready. And he's certainly ready the week I had carved out, but the state has a conflict in the sense that that lead investigator can't be there. That next week that I've carved out, your lawyer has the conflict, so it sort of balances out. None of that should make you happy, but I'm just letting you know it's not the state saying we're not ready, we're not ready. It's a mix, and we'll move the case forward. Do you have questions about what I shared with you?
No, I can wait.
Okay. So I will see you in the next week-ishness, either to talk about bond or to take whatever plea has been negotiated or is a non-negotiated plea, but you understand what the ranges are. I'm going to be sending an email out today to the prosecutor and your lawyer, making sure we're getting that on the calendar. That being, let's get everyone back together, and at a minimum, we talk about bond. And if that doesn't work out well, it may be you say, well, then I want to explore this plea. Don't know. And there's always that fallback of getting the next available trial date. Mr. Johnson, are there other things you want to cover?
I think you covered it.
All right. Well, I appreciate you being here, Mr. Johnson. Mr. Wright, we'll bring you back as soon as we know what that day is going to be. All right.
Maybe excuse you.
1 second. Mr. Abate, not your case, but anything you want to add from the state side? Okay. All right. We're good. Thank you. Yep.
Say yes, I may be excused, Your Honor.
Yes, sir. Thank you. Good question. I got through the things I needed to. Let's talk with Ms. Cabrera. You have two cases, Mr. Mender, which is just going to be here's where we are, and I'll tell him where we are. I need to know where we are. And then Mr. Gomez, and I know you needed some time to talk with Mr. Gomez. Okay. Have you chatted with Mr. Mender yet, or it's just
I spoke with Mr. Mender, so he's ready.
What are we doing today?
Absolutely nothing.
Okay.
We can't do anything with him, because a lot of it, I think the state still has to speak to their victim, which doesn't happen until Monday.
Right.
And then we'll see what charges remain for Mr. Mender or what's.
Okay. Got it. You're going to speak, the victim's coming here, or you're going to the victim? You're going to the victim. Okay. All right. Well, yeah, we may not, should we just bring, look.
I knew that, you can do it now, so I know he definitely wants to see you.
Okay, and we'll do that 100%. I'm just wondering if we want to bring all three out so they can hear, because this is what we're waiting on. But if you haven't had a chance to even meet your client yet, okay, would you prefer to meet him before I say, here's what's going on? That's fine. It's a fair request. I'm good with that. So why don't you go back and do that, and we'll figure out, and then when you come back out, we'll bring all three out so you all can.
At the same time, talk to Mr. Gomez.
If they'll let you back there. Great. Okay. I don't know if they have like a head count back there. That works. Okay. Great. Well, you're back there. Let me talk to Ms. Rios and Ms. Wood. All right. Ms. Wood, Brian Hall, ready?
Not yet.
You need to talk with him more. Okay. Mr. Benjamin, Mr. Abik, oh, not here. I bet he didn't leave. The guy with the coveralls? He's outside. Any update on Mr. Abikwe? We'll find out. That's his lawyer. Oh, he's a Dilligard case. Thank you. Have you seen Mr. Abikwe yet?
No, and he called me yesterday. I was before. I tried to call him back, and I didn't able to reach him.
Okay, we'll figure it out. Mr. Gomez, we just talked about. Mr. Gill, did you end up talking with Mr. Gill?
And his family judge. I don't see him at all.
What are we doing with Mr. Gill?
Well, I'm not sure yet, Judge, because they wanted to have a conversation without me.
Family did?
Yes.
Okay, so they may be doing that.
Yes, but he does the log back on, Judge.
Okay. Hold on 1 sec. Hey, Mr. Benjamin.
Yes, sir.
Did you reach your lawyer?
Yes, sir.
All right, we're gonna try. Ms. Nelson, can you try to reach Mr. Abikwe's office to figure out his plan?
Yes.
Thank you. I'm sorry, Ms. Wood, back to Gil.
Yes, so I will have an announcement shortly.
Okay, after the family talks.
Yes, Judge.
We dealt with Mr. Wright, Mr. Jintao.
I just spoke to him, Judge. He's my client who's in the wheelchair.
Yeah.
He was having trouble getting a ride down here.
Okay.
I hope Miss Clark is still in the vicinity, because I'm gonna.
She may be she likes pre-trying in there. I don't know if her stuff's still here.
Yeah, this is the home.
Oh, she's talking with a lawyer in the hallway.
I'll talk to her, but, so he's working to get down here.
Okay. Does he have a way to get that?
So he has a caregiver that transports him, and there was a misfire. He, for whatever reason, thought court was at 1:30 today, and the caregiver wasn't scheduled until 1:30.
Okay. Got it. Mr. Estrada, you guys are working on that. Mr. Okoro is probably thinking he'll just be here at 2. Wilkins, bench warrant. Mr. Thomas, you guys still talking?
Yeah.
All right, keep talking. Ms. Scott, we think is a bench warrant. Juan Scott? Nope. Okay. Mr. Johnson.
I still need to talk to him, Judge.
Okay. I guess it's good news for him. So he has 2 other cases. He has no bond in either of those cases. He is out and he's going to stay out for today. They're actually not both Farmer cases. One is Edwards, one is Farmer. The alleged incidents occurred on the same day, 2 different alleged carjackings, but separate, so they're indicted separately. Both were dismissed for want of prosecution because the same Union City officer didn't show up on 2 different days. So there were prelims, one for each incident. And in January, 2 different days in January, Officer Bad didn't show up. And so Judge Drake dismissed carjacking 1, carjacking 2. Our case happened long after that. So he is out on a $25,000 bond that he posted in June of last year for our case. That is a valid bond and not revocable. But there is that awkwardness because the DA's office didn't get a grand jury warrant, that he has 2 carjacking cases with no bond, but not as in I'm in no bond status, as in there's just no bond. He doesn't need to show up to court if he doesn't want to, because there's not, if he gets a summons. But that's the overall status in terms of sureties and bonds and whatnot. 1 bond, 3 cases, carjackings, each one. DA's office. So we'll come back to that because you're still talking. How about Mr. Ferguson?
He's in the hallway. My investigator should be here soon, and then Miss Charles's investigator is here.
Oh, this is the phone.
And Miss Rios is kindly going to step in for me. since
Thank you,
I
Miss
have a lot
Rios.
going on this morning.
You do?
So she's gonna link up with my investigator when she gets here, and they're gonna speak.
Look at the phone.
Yes.
Excellent. And he brought the phone.
Yeah.
And it works.
Yes, so yes.
Okay, good. So we're waiting on Ms. Charles's investigator, and who is empowered from the DA's office to do something about the case? Or is the investigator who will be looking at the phone? That's the investigator. Hey, investigator. Okay. He gets sworn in Supreme Court, and look at the attitude that flows from that. Wow. All right, let's switch seats. Yeah, no, I appreciate it. Be empowered. The investigator is here, so let's make that happen. Ms. Rios has a project now. Kenneth Jones?
That's gonna be a plea, Judge. I just
Okay.
haven't spoken.
You do, okay, I'm only taking attendance again. I'm not saying what the heck have you been doing? That's not my point at all. Cameron Hill?
This will also be a plea. I just haven't ironed out final details. But
Okay.
it will be a plea today.
Patience, everyone. And then Jason Nickerson.
He's in the hallway waiting for me.
Same thing. Okay, why don't we let you go do some things and Mr. Rhodes, did you get to talk with your client? I did. Good, okay. So we're just waiting for Ms. Cabrera to come out, and then we can talk about what's happening with the Horn Rogers Mender case, which is sadly nothing today, but at least you've had face-to-face now. Good, okay. Do you need discovery, or Ms. Hill got it to you? Excellent. So when Ms. Cabrera comes out, we'll have to get everyone out. I don't know if there are other lawyers back there, because we'll bring all 3 juveniles out at once. And they can stand or sit, wherever is better for you guys, but it's just a quick conversation.
Counsel, we ready for the brief, you out. Go to the podium, was that podium? Go to the
first
podium.
one.
Come on, let's do right here. Podium.
Mr. Francis, can you two switch sides?
Okay.
Thanks. Here you go. You can keep talking. Okay. So gentlemen, I just want to give you an update of what's happening. Let me make sure I am getting this the right way. So Mr. Horn, you have a new lawyer. Your lawyer, Ms. Hill, ended up having a conflict, meaning she at some point represented someone connected to this case, not necessarily either the two gentlemen here, but if I recall, there were 6-ish people who were originally arrested or investigated. She may have represented one of them. She might have represented the gentleman who got shot in the case. But regardless, she had a conflict where she couldn't give you her undivided focus because she knew something about someone else who might be a witness in the case. And so she did the right thing, sent me a notice saying, I have to step back from the case. Nothing to do with you. And she very promptly got a colleague to step in her shoes. That's Mr. Rhodes. He is now your lawyer and will be with you through the end of this case, whatever that means. Ms. Hill had filed 2 pretty important motions on your behalf. One of them was a demand for a speedy trial. And Mr. Rogers, your lawyer, filed the same thing. That's a way of saying, Judge, we want a trial ASAP, tomorrow, if you could do it. I can't do it tomorrow, but real soon. So we will, if your case is going to be a trial, we're going to do that soon. It was supposed to be not next Monday, but the Monday after. I had set it up that way, but the fact that Ms. Hill had to step back from the case means we can't do it then. It's not fair to Mr. Horn because it's not realistic to say Mr. Rhodes would know everything and anything about the case. And more importantly, have had enough time, Mr. Horn, to talk to you about the case. So we're gonna have to delay it a little bit, but that speedy clock is still running. I still need to get you all in here for a trial if it's gonna be a trial. Mr. Mender, your lawyer didn't file a speedy trial demand, but your case is gonna move along with theirs. And we'll see how the different cases resolve. Mr. Horn, I mentioned your lawyer, Ms. Hill, had filed another motion. It's this immunity motion that she filed, which argues that you ought not to be prosecuted in this case because you were acting in self-defense, or there are a couple other reasons where if it's proven, I have to make the case go away. I think Mr. Rhodes is going to look over the case file. There's video of what happened. He's going to watch that. And then he's going to let me know whether he wants to still go forward with that motion or not. If he does, we've got to hear that before we can do the trial. So that's sort of where we are. Mr. Mender, do you have any questions about anything I just said? No? Okay. Ms. Cabrera is going to be continuing to talk to you. Mr. Horn, do you have any questions about anything I said? I said a lot.
No.
No? Okay. Mr. Rogers, do you have any questions? Okay. Mr. Dennis, anything else we need to cover on behalf of your client?
Judge, we will have to eventually go on the record with the issue that me and Ms. Cabrera have, being law partners, and we have 2 clients on this case. Their defenses are not in opposition. We don't see that as being a conflict, but eventually we'll go on the record.
Okay. Well, we'll do that in just a minute. Okay. I appreciate you reminding me that you flagged it before. I'm aware of your business relationship. Okay. Let's do that in a second.
Okay.
Mr. Rhodes, anything else on behalf of Mr. Horn?
Nothing else, Judge. You covered it. I will go over discovery and I'll be talking to Mr. Horn in much more detail in person with the YDC sometime over the next week.
Okay.
But I'll let the court know promptly if I find that motion still to be appropriate for next week.
Okay. Do you need an order from me to be able to get equipment into the YDC so you can show Mr. Horn the video, or that's not part of what you were going to engage him with initially?
I shouldn't need it.
Okay. If for some reason you do, just reach out to Ms. Nelson and we'll get you that kind of order.
Okay.
Okay. All right. I'm gonna have Mr. Horn go back right now unless, do you need him to stay up or are you done talking with him today?
I'm finished with him for today. But
Okay.
I'll visit him soon.
All right. So Mr. Horn, you're gonna go with the deputy right here.
Yeah, Judge, are the other two staying out?
They are.
So he can just stay, because I can't leave Gordon by himself.
Got it. I wouldn't want to be by myself with Gordon either. So, but I need them to rotate. So then Mr. Horn, yeah, and Mr. Rhodes, if you take the place of Ms. Cabrera and Mr. Mender, and they'll slide in.
Then the Gordon just take notes of what the judge just
No,
said.
he's denied.
Take notes.
That's why I thought speed trial, trying to get you up. All right, we're going to go on the record right now. We have in court the three defendants in the case 25 SC 000816, and I'm going to have a conversation right now with two of those three, Mr. Rogers, who's represented by Dennis Francis, and Mr. Mender, who's represented by Ms. Cabrera. Mr. Francis, why don't you get on the record the issue, lowercase I issue, that I think we're going to clear up, and then I'm going to chat real briefly with your client and Ms. Cabrera's client.
Right. Well, Ms. Cabrera and I have a business relationship. We have a law firm together. But this case was appointed to both of us through different means. This case was appointed to me through Georgia Public Defender Counsel. It was appointed to her through Mr. Lewimba's contract with the Georgia Public Defender Counsel. And so we just need to put on the record that we don't, the defenses are not in opposition. We don't see a conflict, but it is an issue that needs to be addressed and that the defendants need to be made aware of.
Sure.
So that they can make their objections known if possible.
So, Mr. Rogers, you're entitled to a lawyer who is focused just on you and not thinking about, well, what's good for these other defendants. Mr. Francis's goal needs to be getting the best possible outcome for you, whether that's a plea, going to trial, winning a trial, or who knows what. But that needs to be Mr. Francis's focus. And I'm confident that's his focus. He happens to be a business partner with the lawyer for Mr. Mender, who's your co-defendant. Sometimes defendants have conflicting defenses. One defendant says, I didn't do it, Rogers did it. Or you're saying, I didn't do it, Mender did it. Mr. Francis is telling me that's not how this case is going to play out. And it's on video, so it would be kind of hard for someone to say, this guy did it, when it shows on video that one person's standing here and another person is standing there. I need to be sure that you're comfortable that Mr. Francis has your best interests in mind and you'd like to keep him as your lawyer. Is that what you'd like to do?
Speak out.
Yes. Will you let me know anytime I see you if you start to have any concerns that, wait a minute, I think Mr. Francis is really trying to do a deal for Mr. Horn or for someone else, and he's really not focused on my interests. Will you let me know if you have that concern?
Yes, sir.
Okay. Mr. Mender, same situation for you. You've got a lawyer who I know is focused on what's in your best interest. And you and I and your lawyer have been talking about that. We've been talking about your bond, things like that. She also happens to be a business partner with the lawyer for Mr. Rogers. I don't see that as an issue, but I need to make sure you're comfortable having Ms. Cabrera as your lawyer and that you think she's working pretty hard on your behalf. Is that what you think?
Yes.
Okay, so you're okay having Ms. Cabrera be your lawyer?
Yes.
Will you let me know if you ever change your mind about that?
Yes.
Yes, great. Okay. Mr. Francis, thank you for bringing this to the fore again, but this time on the record. I find that Mr. Rogers is knowingly and intelligently waiving any potential conflict. I don't see a conflict, but insofar as there could be one, at this time, Mr. Rogers is waiving that. And in the same way with Mr. Mender, I find that you, Mr. Mender, are waiving any potential conflict. You're very comfortable with Ms. Cabrera being your lawyer, and I'll leave those two lawyers in place as your lawyers. We can revisit this at any time if either one of you starts thinking, wait, I'm not comfortable with the lawyer that I've got. Anything else, Mr. Dennis, on behalf of Mr. Rogers?
No, Your Honor.
Ms. Cabrera, anything else on behalf of Mr. Mender?
No.
All right, and one more time, Mr. Rhodes, anything else on behalf of Mr. Horn? Thank you, all three of you, for your representation. We'll be in touch soon about when we can get this back on a trial calendar, given the 2 speedy trials. All right? Thank you.
Thank you, Judge.
You got any questions?
Well, Judge. You talking? No, you're good. Stay right there, stay right.
Judge, Madam Pro.
Yes, sir.
How you doing?
I'm well. What's up?
All right. Your son's graduating.
He is.
Because my son's the same class.
What's
He's at Mays.
okay?
Now.
Where's he going?
He actually, you know, he was supposed
Yeah,
no, he's a shorty.
that's all right.
He actually got an offer from a small school in Southeast Georgia called Freedom Park.
Fantastic.
Yeah.
Okay.
Yeah, he wants.
So he have a signing day and everything?
Well, you know,
Hey.
it's kind of, you know.
That's exciting.
Yeah, it is.
Good.
They have
Is that a 4-year?
It's a 4 year. Great. They have a developmental program now because they changed the rules last year so that if you go to junior college, you retain the 4 years.
Yeah. Because my son kicked that around, like, you're not going to junior college. Right, Dad, come on. Like, it's not, just take it off the
That was
list.
the thing. See, I didn't know. He was like, I'm in junior college. But then, so schools like Ruby Park have developed an in-house program to where you can play certain number of games and it doesn't have to ability. Then you practice with varsity. Yeah.
That's great.
Yeah, so what about your son? Was he?
He's going to Brown.
Okay, good.
Going to Brown. He's going to pitch for them.
Oh, really? Okay.
Yeah. So he's excited. I'm excited. And he's in a place where if, heaven forbid, he messes up his arm, he's
Yeah.
getting a good education.
Exactly. Okay.
Yeah, so we're excited. Graduation is next Saturday. How about you guys? Oh, yeah, because my other kid's in APS, so it's that same schedule. You gotta get to the end of May.
Okay.
Good for you. Congrats. All right.
My Yankees need him. I hope you don't listen to my Yankees need. Can you step at the bench about 5 minutes?
You gotta get someone downstairs.
The guy was turning toward.
Yeah. I know who you're talking about.
I'm taking down.
Okay, all right.
I'll be back in 5 minutes.
Yeah, let me take one announcement and then they have more talking they need to do. You do? Fantastic. All right. So are you guys good to go? I'm gonna let the deputies take, we have a slightly unruly gentleman down there who's gonna get taken downstairs. When he comes back up, we'll start with that.
5 minutes.
You don't? No, we'll just get it all on the record. Okay, thanks.
Okay. So,
Gomez.
Yes.
I don't know what the flow of your calendar is.
Today or
For the
the trial week?
Yeah, for your trial calendar.
Rogers, Horn, and Mender aren't on it anymore, so I have one case and the guy's not in jail, so Gomez would go ahead of that.
I need an opportunity, so we did the evaluation on him.
Mhm.
They find that he's competent enough to stand trial, but he does have schizophrenia and it's a
Oh,
whole
yeah.
of things
Yeah,
happening. I want to, the state is considering whether or not they would do something else. They're still in the same place. I'd like an opportunity to counter, to give them a counter offer. I'm not asking for him to come off the calendar at all.
Yeah.
I'm just asking for him to not be the trial that you called May 19th or
Okay.
whatever that date is.
so what does that mean? What's the next step for this case?
Me present them with a counter offer of sorts. They had to resend me the link. It's saved, part of it is saved to my computer, but the link it expires. So I can't get back into everything. So she's resending it to me.
Okay.
I want to go over some things with him, talk to him. And he doesn't really want to have a trial.
No, I remember the last time he sort of strode into court saying, I am ready to resolve my case.
Right. He's
But you're
like-
far apart right now.
Right, very
Okay.
far apart. So I'd like to be able to look at some things, go on ahead and present the state with a counter offer now that she's spoken to Mr. Rao, and they're kind of where they are.
Mhm.
Present them with a counter offer, and then what it may be is a
A
non-negotiable.
non-negotiated plea.
Right.
Okay. Tell me a realistic time frame for you to be able to do those things. Because I don't mind your request, but
Mhm.
what I don't want to do is say, well, that means it goes to the August trial calendar. One, I'll put it on another trial calendar, but this situation's a little tenuous, and while you are able to connect with him now, and he's taking his medication, things could happen where in a month, then you lose that connection.
I don't mind him, coming on the 19th or whatever.
Okay.
I just don't want it to be
That is a
the jurors
trial.
are in the hall. maybe the 19th is our attempt at a non-negotiated
Okay.
plea.
Okay.
I just wanted to give you realistic expectation
Got
of
it.
how I think he needs to be handled.
If we did it next Friday, my civil trial won't take the whole week.
Mhm.
And I just soon have Monday be people who are coming in actually going to trial.
Right.
And we know this won't be, and so
Right.
someone could plead if we bring him in, but if we had him come back here next Friday, does that give you enough time?
I would.
Assuming you're in, this zip code?
Even if I'm not, I'll show back up. Next Friday is the 16th.
If you say so.
It is.
Yes.
Next Friday is the 16th in the morning. Sure. I have court not till 1:30.
Okay, so if
So
we
we do-
set it down for 9 next Friday, because if I, for whatever reason, am still in my civil trial, I could just have the jurors show up at 10 that day.
Okay.
But let me check with Ms. Nelson. Are you objecting? You're not here next Friday? Oh, look at that. We'll figure it out. Michelle's not here either. I have to borrow a 9 next Friday.
Okay.
All right?
Okay.
Waiting, please.
And then I have to get off the bench so they can get this guy.
Yeah, and then we need to
Okay.
sign that.
And I'll go on
disposition.
ahead. I'll talk to the state and I'll go see Mr. Gomez.
Okay,
Then
do you
we'll just-
want me to talk to Mr. Gomez or he's good?
No, I've spoken to him. He's
Okay.
fine. He knows what I'm asking for.
Okay.
That's it.
Who stand up? Who stand up? Who don't? Take a place.
No, schizophrenic kind of stuff.
All right, I'll go away. When I come back, we'll do, Mr. Bench, Mr. Thomas, is that Mr. Thomas? Yeah, we'll do Mr. Thomas. Okay.
Yeah, about 5, 7 minutes. Be ready.
You just come, I'll know because one of you comes back and says, come on.
I'll let the guy that you won't be along with.
But I'm gonna, I'll be able to, I'm offer. Now.
13, what up? 13, 5 minutes?
When you're done, you need to go to Judge Ingram for a plea. Busy day. Okay, I'm going.
Yes. But the meeting was last. So.
Hey, Gordon, I'm gonna check on Harlan. Okay. Be back in about 5 minutes. All right.
All right, let me adjust one thing here, get the witness. There we go. All right, Madam Court Reporter, are we ready? Thumbs up. All right, let's get on the record then. We have position 15. Get there. Tariq Thomas, who's represented by Mr. Ben Shida. Both are in court. Ms. Clark, the prosecutor, is also in court. And Mr. Thomas, I understand you're ready to enter a plea. Is that correct?
That is correct, Judge.
Okay. In a moment, Ms. Clark is going to put you under oath. Once you're under oath, please answer her questions truthfully and completely. And let me or your lawyer know if you have any questions of your own. Will you do that?
I will.
Excellent. Ms. Clark, when you're ready.
Yes, Your Honor. Before I start with the colloquy, Your Honor, I wanted to say that for the record, the state will be cruelty to children in the first degree under 16570B. The state will be amending that to 16570D, which is cruelty to children in the third degree.
Is that a misdemeanor?
Yes, Your Honor.
And my calendar says there are 2 counts. Is
Yes.
that happening for both counts?
Yes, Your Honor.
So this is a misdemeanor plea to 2 counts?
Yes, Your Honor.
Got it. Thank you for flagging that.
Please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
You can put your hand down. Please state and spell your correct legal name.
Tariq Thomas, spelled TarikThomas.
Are you at this time taking or under the influence of any medication, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
I'm 26 years old.
What's the highest level of education or the last grade you completed?
I completed high school and started trade school, didn't finish.
What kind of trade school?
I was trying to be a CNA.
What's a CNA? A nursing assistant?
Yes.
Got it.
Mhm.
Do you understand that you have been charged with the following offenses? 2 counts of cruelty to children in the third degree, which is a misdemeanor offense.
I do understand.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
I do.
Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
I do.
Have you had an opportunity to review the indictment with your attorney?
I have.
And did you understand the indictment and the charges within the indictment as explained to you by your attorney?
Yes, ma'am.
And have you had an opportunity to review your waiver of rights?
I have.
And is it your decision to waive your rights and participate in this plea today?
Yes, ma'am.
Have you had enough time to speak with your attorney about the charges in the indictment against you, including the facts and circumstances relating to these charges?
Yes, ma'am.
Are you satisfied with your attorney's services?
I am.
Do you waive attorney Shida? Is that right?
Yes, Ben Sheehan.
Do you waive a formal reading of the indictment?
We do.
Do you waive any defects in the indictment for purposes of this plea?
We do.
Do you understand that you're entering a negotiated plea of guilty, which means that the state and defense jointly will recommend the following sentence to the court? For cruelty to children in the third degree, the state's recommendation is 12 months probation with the special condition that the defendant complete a parenting class and have no violent contact with the child, in this case, Koji Thomas. And upon successful completion of the parenting class, defendant would be eligible to have his probation terminated after 6 months. For count 1 and for count 2, the state's recommendation is the same, 12 months probation to run concurrent with count 1.
Okay.
Is it your understanding of the terms?
Yes, ma'am.
Do you understand, I'm sorry, wrong thing. Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
I do.
Do you understand that as there are multiple charges in this case, that the court has the right to run those sentences consecutively, meaning one after the other? But in this case, the state's recommendation is running those concurrent at the same time.
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you do have the right to withdraw your plea of guilty
Yes, ma'am. Thank you.
and demand a jury trial? Sorry. Are you currently on probation or parole?
No, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Understood.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence? And the special condition in your case is to complete a parenting class.
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Understood.
Are you a United States citizen?
I am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
I am.
Have you ever pled guilty or no contest to a felony in the state of Georgia?
No, ma'am.
Have you ever pled guilty to a felony in any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
He has.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked?
Understood.
You understand that this means that you could be adjudicated guilty and you could be resentenced up to the maximum sentence for each charge in the indictment against you?
Understand.
Do you understand that by entering a plea of guilty today, you're waiving all defenses, including any mental health defenses?
I do.
Do you understand that by pleading guilty, you're giving up the following rights: the right to trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Is it your decision, Defendant Thomas, to waive these rights, which means not to use them, and to enter a guilty plea today?
It is.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No, ma'am.
It's the state's understanding that the defendant will be seeking to do an Alford plea. So I will proceed with that. Is it your decision to enter a guilty plea because you are in fact guilty?
No, ma'am.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Understood.
As to indictment number 24 SC 004822, how do you plead to the 2 counts of cruelty to children in the 3rd degree?
Guilty under Alfred.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Understood.
Do you understand that for a misdemeanor charge, you only have 12 months from today's date to file that petition?
Yes, ma'am.
Your Honor, at this time, the state can provide a factual basis for the plea, but being that it's a misdemeanor plea, defense counsel said that they would be willing to stipulate to the factual basis.
Okay, I'm a little curious, given what was alleged, how it's turned into misdemeanors. Count 2 sounds particularly serious.
Right.
And so I'm not second guessing the way this is played out, but presumably Koji Thomas had a broken bone. Here it's a misdemeanor plea. I'll note that that was 4 years ago, but that doesn't make it less of a broken bone.
Right. So, Your Honor, with all my cases, I do my own investigation into the case. I looked and there is no DHS history with any encounters with the defendant as well as the mother of the child before this incident and after. Also, Your Honor, I did speak with the mother today and got some clarity around, I guess, the child's whereabouts. So it's the state's opinion that there was an explanation provided by the defendant to the authorities regarding the child being left unattended in a swing. And so the initial examining physician attributed that to the actual fracture. However, the child pediatrician from CHOA disagreed with this.
So there was a difference between the experts as to how the bone was broken.
Yes, Your Honor.
Okay.
But I believe that based off of my interview with the mother and the fact that they don't have a prior any history with the child, and from talking with the defendant myself, I believe that even though there were injuries to the child, I believe that in this particular case, they were not, the child was not abused that rises to the level of the cruelty to children in the first degree. But I do feel that because the child did fall from the swing, and the defendant at his own admission admitted that he left the child unattended in a room, I do feel that at least the cruelty to children in third degree is appropriate.
Okay, appreciate that. Good morning, Ms. Jackson.
Good morning, Your Honor.
Do you have any criminal history information for Mr. Thomas?
There are 2 cycles. The last arrest was February the 9th, 2020 in Clayton County for driving while license suspended or revoked. He has 1 misdemeanor sentence that was in 2020 out of Clayton County. He received a nolo contendere sentence for driving while license suspended or revoked. Nothing in addition, Your Honor.
Thank you. Mr. Benchida.
Yes, Your Honor. Just to give you, to add a little to the state, we believe this is the second best resolution. Of course, full dismissal will be number 1, but we think this is a good resolution to this matter. My client loves his son. Even after that, like the state and I spoke, there were differences in how this could have happened. They did an investigation. At first, the officer closed his investigation. A month later, a different expert was like, no, it could be this. That's why they reopened it. They took the child away, I think, for a month. They did parenting together, but he's willing to do another parenting class. And then for a month, they had the child with a relative, brought the child back, and he's been with them for over 3 years now. Growing healthy. He has regular appointments with their pediatrician. Mom, dad, everyone's great. Even in the medical report, the first medical provider was like, outside of these injuries that were explained, the child's healthy and good. So because of that, we're closing it. No criminal history, Your Honor. He does work. He opened his own business. He's 26 years old, Your Honor. Him and the mother, like I said, they have a great home, great support system.
So they're still together.
They live together. Yeah, they all live together.
All right.
The child and parents all live together. They have a great support system on both sides. The mother and the father, both grandparents, everything. So there's no issue financially. Of course, we all have stress with children, but they have a great support system. So, if they need a breather, they have that.
Okay.
So we ask, Your Honor, that you accept this negotiated plea. We're asking for first offender just to continue. He has no issues, like I said, on his record, but for the traffic violation, we know going forward he won't have anything. We ask the court to accept that. We know that he would qualify for that, and he'll be a great candidate for it. He pleads under Alfred, Your Honor. He does know that, now there's been more watch of the child So there's not been any issues since this, and he knows and mom knows that it won't be any issues going forward. So we appreciate you hearing us out. We just ask that you take the plea as the state and I announced it, Your Honor, and we thank you for your time.
Okay. Mr. Thomas, what's the business that you opened?
It's a 3D printing business.
How long has it been open?
Not too long, Your Honor. I've gotten like orders from friends, family members, made about $300. So it's newly open. I got my 3D printer like 2 months ago.
Okay. What were you doing before that?
I'm still doing it. Actually, I'm working at a gas station at night as a clerk.
Okay. And then does your son's mom work?
She does.
What does she do?
She works in a, what is it? It's a hospital where she just transfer records.
Okay.
Yeah.
Got it. And Koji is how old now?
He is 3 years old, about to be 4 coming up, and yeah.
Yeah, he had to be turning 4 soon. I mean, otherwise he would have been 0 when this happened. Okay, so he was super little when this
He
happened.
was 4 months old.
Okay. Any other kids?
No, not yet.
Not yet. Okay. All right. Do you have any questions about anything we discussed?
No, Your Honor.
First offender, you are eligible for and you qualify for, and I'll let you use it. You just need to understand you only get one first offender, and most folks don't use it on a misdemeanor, but you're certainly entitled to do that. If you're pretty confident you're not going to be getting in trouble anymore, then when you leave here today, this is not a conviction. And when you're done with your probation, it's not a conviction, and it stays that way. But I'm making this up. But if 3 years from now you are driving a car and you think it's a clean car, but it's a stolen car, and you get arrested for some kind of felony, you can't use first offender again because you've used it on this misdemeanor. As long as you understand that, I'm not trying to discourage you from using first offender, but every once in a while we'll get someone in here and the lawyer said, regrettably, my client used his first offender on a misdemeanor, which is a less serious thing. I wouldn't want a misdemeanor on my record. I don't think you want one on yours. But that first offender is consumed by this plea if you use it here. Do you understand that?
I do understand.
Okay. And you want to go forward as a first offender? I do. Definitely. All right. Well, Mr. Thomas, I find there's a factual basis for your plea. Your plea is knowing and voluntary. I will sentence you as a first offender. And this is an offered plea on count 1. I'm sentencing you, which has been reduced to cruelty to children in the 3rd degree, 12 months probation. A special condition of that probation is you complete a parenting course. I know you've done one, but never bad to get a refresher. You'll need to do another one. If at the end of 6 months of your probation, you've taken care of that parenting class and there have been no other issues, then your probation can be terminated early. Count 2 is also 12 months probation. It will run concurrently with count 1. Mr. Benchita, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Clark?
Yes, Your Honor.
And Mr. Thomas, can we electronically sign your name to the indictment indicating your offered first offender misdemeanor plea?
Yes, Your Honor.
All right. You're going to get contacted. You will be contacted by either your lawyer or misdemeanor probation directly. Make sure you connect with them so they don't send me a warrant saying we can't find Mr. Thomas.
Gotcha.
Okay.
I will.
If there's nothing else, Mr. Benchita, we are all set.
Thank you, Your Honor. That concludes our business. May we please be excused?
You may. Thanks for your time.
Thank you.
Your Honor, may I please?
Yes, go to 7E, please.
Be back at 2.
All right. Mr. Benjamin, Mr. Abikwe, we've learned, is on leave. He had a family situation. He actually sent us a letter. I just didn't see the letter till recently. So I'm going to excuse you. I'm assuming that is a case that's worked out, or you hadn't quite closed the loop, Ms. Dilligard?
I haven't quite closed the loop.
Okay. When Mr. Abikwe is back, we're gonna try to get you in here. Rather than wait till the next trial calendar, which is months away, I wanna get you in here before then. So I'm gonna bug your lawyer to see if we can get you in here to sort things out. But today you're free to go and you're not on the trial calendar anymore, okay?
Thank you, sir.
All right, thanks for your patience.
Yes, sir.
So, Ms. Wood, we have time for one more plea before I need to break for lunch to deal with a meeting, and then we'll pick right back up from there.
Okay, I have, do you have a minute or do you? Okay, I'm gonna let her go, Judge, but I do have a quick announcement.
Okay,
Position 22, Jason Nickerson, he is in the hallway, he's coming back in, he's feeling unwell.
uh-oh,
It's not gonna resolve today, so I asked that he be excused.
okay, let me, so that was gonna be resolved, it's not gonna be resolved, so I should move it to the trial calendar? Okay, I will do that, so that goes over here, 22 Nickerson, and you've got good contact info for him?
Yes.
Then he is free to go, and he goes on our very short list. I don't see Mr. Jintao yet.
Still working on that.
Okay.
And Ms. Clark and I are still working on possible resolution for that. So
For Jin
I know
Tao.
she just left, but we're still talking.
Okay, and people are crunching the Ferguson phone?
They're back there, I think.
Good.
Yes, yes.
Okay.
And then one more announcement, Anthony Johnson, he's sitting right here.
Yep,
If we could leave this one on, Ms. Dilligard is trying to get discovery from new cases to me.
Okay.
So if it needs to stay on the trial calendar, I would ask it maybe be at the bottom of the short list, because I'm trying to get a global resolution going.
okay. I'll move it to the short list for trial. And hopefully she can get you discovery in those other two cases. They're both Union City, and they will be in one place, that discovery. It was all the same day supposedly. And you have good contact information for Mr. Johnson?
I do.
Okay, then he's free to go.
Thank you, Judge. And then I'm working the final details out, but please on position 1, Paul, and position 21, Mr. Hill.
Okay, what about Jones 20?
He is a plea, I just haven't seen him yet.
Okay, oh, he's in custody. And make sure it's yours. Oh, it was a bench warrant. Never mind. It was yours. No, it's Ms. Rios'. She didn't show up. Okay, that was bench warrant. Leak Wright pool. That's it? Okay. Then Mr. Estrada, if you'll come on up, I need to text something and then I'll come take the plea.
It's one of the conditions of school.
My question. Coming in the first offenders, I cannot go to the fire academy anymore. I could put.
I mean, that question's better for them, but see. From a legal standpoint, you're fine. But for them, I don't know what their qualifying criteria is. But
Okay.
When do you plan on applying for that?
I was gonna try to apply for it.
Really?
So I'm gonna go home.
Awesome, I can totally see you do.
Taking a plea?
Yeah.
Got custody?
No.
Okay.
So we're good.
Oh, did that go plea? Okay.
No, he is, but he's not in custody. All right, we're gonna go back on the record. Position 9, State versus Isaac Estrada, 24 SC 004572. Mr. Estrada is up at the podium with his lawyer, Ms. Alejos. And Mr. Estrada, I'm told you're ready to enter a plea, is that right?
Yes, Your Honor.
Okay. Ms. Dilligard will put you under oath in just a moment. Please answer all her questions, and please let me or your lawyer know if you have any questions.
Yes,
Okay, let's go.
Mr. Estrada, can you please raise your right hand? Do you swear or affirm that Any statement or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can lower your hand. Please state your true and correct legal name for the record.
My name is Isaac Estrada. ISSA. Oh, I spelled it. I'm good.
You don't have to. Thank you, though. Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there any medication that you normally take that you've not taken today?
No, ma'am.
How old are you and how far have you gone in school?
21. I've got about a year in college.
Do you understand that you've been charged with the following offenses? It's 1 count of serious injury by vehicle, a count of reckless driving, 1 count of driving on the wrong side of the road, and driving without headlights.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent or refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about the charges in this indictment, including the facts and circumstances related to the charges?
Yes, ma'am.
And do you need any more time to discuss the case with your lawyer?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment and waive any and all defects for purposes of the plea?
Yes.
Mr. Estrada, do you remember having been arrested on these charges?
Yes, ma'am.
And has your attorney advised you of the minimum and maximum sentence for each charge which you're pleading guilty to today? For the serious injury by vehicle, the range is 1 year to 15 years. And for reckless driving, it's 1 day to 12 months. And Judge will be no processing counts 3 and 4.
Okay, so just 1 and 2.
Yes, Judge.
Okay.
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the recommendation to plead to counts 1 and 2 to a sentence of 3 years of probation, to complete a live at 25, 50 hours of community service, and to stay either enrolled in school or remain employed.
All right.
Is that your understanding of the recommendation?
Yes, ma'am.
Do you understand the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that if there are multiple charges to which you're pleading guilty to today, the court has the right to run those sentences consecutively?
Yes, ma'am.
I believe we reserve his final plea rights. Do you understand that if the court decides to order a sentence that differs from the plea you were expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
No, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that if you're placed on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
And do you understand that if you fail to follow the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you ever pled guilty to a felony in the state of Georgia?
No, ma'am.
Have you ever pled guilty to a felony in any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
Yes, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status can be revoked?
Yes, ma'am.
This means that you can be adjudicated guilty and you can be resentenced up to the maximum sentence for each charge in this indictment. Do you understand?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
You understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial.
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Mr. Estrada, how do you plead to the charges of serious injury by vehicle and reckless driving and indictment number 24 SC 0044572?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
Do you understand that for a felony charge, you only have 4 years, and for a misdemeanor charge, you have 12 months from today to file that petition?
Yes, ma'am.
Judge, if this case were to proceed to trial, the state contends that the evidence will show that on the date in question, officers responded to a motor vehicle collision where when officers arrived, there were 2 vehicles that had attained severe damage. The victim's car, which was a white Honda Accord, and the defendant's car, which was a Ford Fusion. The victim had to be removed from the car and taken to Grady for her injuries. The victim sustained injuries to her right leg and her wrist. Witnesses on scene said that they observed this defendant's car trying to pass the victim's car, but while doing so, crossed the double lines and hit the victim's car head on, which caused a vehicle collision. So the victim's car was coming this way.
Yep.
And
Oh, he was trying to pass someone else?
he was trying to pass the car in front of.
Okay, not Ms. Helton's car. He's trying to pass whoever's in front of him. To do that, crosses double line, and there's a car going the way it should in its own lane of traffic. Head-on collision. Ms. Helton sustains these injuries.
Yes, Judge.
Okay. All right. Anything else?
Judge, we have made several attempts to contact the victim to give her notice of the resolution, and said she could be here, but we were not successful.
Okay, so we don't know how she's doing. The indictment says that her right hand, leg, and foot were rendered useless. You don't know if they were removed, if they were just broken
I
or
believe
bruised?
they were just broken.
Okay. We don't know whether she's
I don't-
ambulatory anymore?
I do not.
Okay.
Judge.
All right. And you are dismissing counts 3 and 4?
Yes, Judge.
Okay. Ms. Jackson, do you have any criminal history information for Mr. Estrada?
Your Honor, there are no prior arrests on file.
Thank you. That qualifies you for first offender. Ms. Alejos, what do you want to add?
Yes, Your Honor. As you know, this has been a lengthy case. It started off in Milton Municipal Court, where he actually entered in a plea for misdemeanors. And the victim actually was contacted in that case, and she was agreeable to that resolution. But given the extent of her injuries, the judge decided to send it back. So here we are. But he has taken responsibility, and hasn't had any priors or no history, nothing since then as well. He's employed. He is preparing to become a paramedic, so he wants to apply. He's waiting for all of this to be resolved, but that's his plan. So I don't think we'll ever see him again in this situation, which is why we're asking for a first offender. We're also asking for a behavior incentive date of a year and a half, which I have discussed with Ms. Delegard as well. And non-reporting on probation once conditions are completed.
Okay. Do you think Mr. Estrada will be able to apply to be a paramedic while he is under sentence? It's not a conviction, so he doesn't have to check a box saying, oh, I'm a felon.
Right.
But he's on probation.
Yeah, we have discussed this. His game plan for now is to wait until all of this is completely behind him, and he's in touch with the academy as well.
Okay.
What's needed for him.
Are you working now, Mr. Estrada?
Yes, sir. I work at Publix Target.
Publix and Target?
Yes, sir.
Okay, 2 jobs. How many hours a week total does that add up to?
Sometimes around like 70 to 80.
Okay, that's a busy week. And I missed one part. I was taking some notes from your file. How far have you gone in school?
I got about a year in.
Into college?
Yes, sir.
Okay, so you graduated high school?
Yes, sir.
Where'd you go to high school?
Sequoia High School.
Okay. All right, anything you want to add?
No, sir.
Did you know Ms. Helton?
No, sir.
No injuries to you?
I had a torn liver and a broken ankle.
Oh, so yes, injuries to you.
Yes, sir.
Okay. All right. How's your liver?
Good.
Okay. Well, if you don't have any other questions, Mr. Estrada, I find there is a factual basis for your plea. You were doing something pretty reckless on the roads and it had pretty serious consequences for you and Ms. Helton. I'm glad everyone survived because we wouldn't be talking about probation or being a paramedic or anything like that if cars had hit in a slightly different way. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, if you have a small issue on probation, I hope you have none, but if you miss a meeting or that kind of thing, a technical violation, that doesn't have to come back to me. You and probation can sort that out. But if you get arrested for anything, any kind of moving violation, do you have a driver's license now?
Yes, sir.
Okay. I don't know what the consequences to your license will be for this conviction. That's not my area of expertise, but I'm just letting you know there could be a serious injury by vehicle conviction could cause the DMV to reach out to you to say you've got a problem. Understand that? It's not new. I'll answer your question in a second. I don't want you to think, new criminal charges. It's nothing like that. But administratively, they may say your license is suspended or I don't know, but I don't want you to be surprised and you can talk with Ms. Alejos about that. But there's nothing she can do, at least directly, because some things by operation of law, you get convicted of X, DMV does Y. So just know that that's out there. And I wish I could be more specific, but one, not my area of law. And two, it's actually not a decision I make. They are notified, DMV, by the clerk's office when there are convictions in certain categories of offenses. And I know, for example, vehicular homicide, that's an automatic suspension of the license. We don't have that here, but serious injury by vehicle might be one of those. Okay?
Yes, sir.
All right. There's no fine associated. I know some of these cases, there's a mandatory fine. And I'm not interested in imposing one absent a requirement for one. So if you don't think I just don't want the sentence to get kicked back because we didn't put the fine in. I think that's the fleeing and attempting to elude where the fine is mandatory. Okay. All right. First offender, I know you've talked about it with your lawyer. I want to make sure you understand the risk of first offender. The benefit is that this is not a conviction, which is great for staying in a job, going to school, etc. The risk is if during the time you are under sentence, you get in trouble for something else, not only could you have your probation revoked, but if what you get in trouble for is serious enough, and I'm the one who decide if it's serious enough, certainly if it's a driving offense like this, if the state can prove up lower burden of proof, not a trial, if they could prove by a preponderance of the evidence that it's more likely than not that you did this new thing, they could ask me and I would likely revoke your first offender status and then I resentence you because you've already pled guilty. And Ms. Dilligard told you serious injury by vehicle is 1 to 15 years. So if we're together again in 6 months and you picked up a DUI, for example, I'm going to revoke a big chunk of that time and turn it into a felony conviction. That messes up being a paramedic, all sorts of things. And I say that not to spook you or to say, I know what's coming with this guy, but I don't want you to be surprised or frustrated or wait, no one told me. That's the risk of first offender. The benefit is it's like this never happened. And of course it happened. And Ms. Helton has her scars and you've got your scars. But on paper, it is invisible to employers and whatnot, which is a great benefit. But there's that risk. If you screw up while you're on first offender probation, it can be a whole lot more serious than, the judge revoked 2 months of my probation. You understand that?
Yes, sir.
And you still want to be sentenced as a first offender?
Yes, sir.
Okay. I will do that. Mr. Estrada, on count 1, I am sentencing you to 3 years probation. Special condition number 1, complete the Alive at 25 course. Number 2, complete 50 hours of community service. And number 3, you need to be enrolled as a full-time student, working at least 40 hours a week. You seem to be doing more than that. Or if you aren't, then for each week that you're not a full-time student or working full-time, you'll need to do an additional 20 hours of community service. So that 50 is just in the background, you're doing that as a consequence of what happened. But if while you're on probation, you decide, I'm not going to work, I'm not going to be in school. And paramedic school counts as school. I don't mean you're enrolled in college. If you're in a trade school, something where you're engaged full time, then you don't need to worry about that additional community service. I will set a behavioral incentive date of May 9th, 2027. So 2 years, not 18 months. If you have done everything you needed to do, at the end of those 2 years, your sentence can end early. It's a little more than your lawyer asked for because this is serious and you're getting first offender, which means this all gets taken off your criminal history. And you will have earned that if after 2 years, you've stayed out of trouble and taken care of your obligations. Ms. Alejos, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Dilligard?
Yes, Judge.
And Mr. Estrada, can we sign for you indicating your plea?
Yes, sir.
We will do that. Counts 3 and 4 are dismissed. Count 2 is, I was going to get there, maybe, 12 months probation, and that will run concurrently with count 1. So it's a total of 3 years felony probation with the conditions that I described. Your address is in what county?
Woodstock.
Cherokee County.
My fault.
Okay, that's all right. You failed the quiz, but you're still going to leave today. I asked because you're going to get probation reporting instructions, and that's county driven. You're not going to report to probation in Fulton. You'll be supervised out of Cherokee. So we're going to finish in a minute, and I'm going to ask you to spend a little time talking with Ms. Simpson, who is with probation, and she's going to tell you where to report and when to report. Do not miss that date. That's when you will meet your probation officer and get signed up for all that. Ms. Alejos, anything else on behalf of your client?
No, Your Honor. Well, I did look up the serious injury by vehicle with the DDS. My understanding is that's a suspension along with the DUI.
Yeah, I did a quick search too, and it looked like it does suspend license.
Okay.
So can I get a hardship?
Probably so. And if your lawyer brings that back to me with documentation for what it's for, I'm happy to engage with that. But I'd start with DMV and get out ahead of it. This is coming and you can say, hey, there's this situation. What can I do? I'm a big fan of letting people continue to work or continue to get to school if they have a means of doing that. So work with your lawyer, and if there's something the judge needs to sign, I'm that person, and I'll do that as long as I've got documentation that you're working and it's not just you going to Dave & Buster's to have a good time. So hopefully that workaround exists, but I'm not promising you it exists. They may say, nope, that's only if you're a super speeder and not serious injury by vehicle. I really don't know how that works.
Yes, sir.
But there's often relief for that type of situation. All right?
We did fill out
Are you the bearer of any more bad news for your client?
No, Your Honor.
Okay. You filled out the plea form. Mr. Estrada, did you go over that form with your client?
Yes, sir.
And initial all the things that applied to you?
Yes, sir.
And signed it?
Yes, sir.
And Ms. Alejos, you signed it?
Yes, Your Honor.
Great. I'll take that from you in a second. Ms. Dilligard, anything else?
I think further, Judge.
Then we are done, Mr. Estrada, with your situation. Good luck with things. Drive carefully if you are allowed to drive. Know this, I'm serious about this. If your license is suspended and you get arrested for driving with suspended license, I want that to come back to me, and that's going to have consequences. So be super smart about what you're doing with your license.
Yes, sir.
Okay?
I appreciate you, brother.
All right. Thank you. Go talk with Ms. Simpson.
That concludes my business. I'm going to be excused.
Yes, ma'am. Thanks for your help on the case. All right.
For the last, for this defendant, the resident in custody.
What?
No, sir.
That Mr. Jones?
Yes.
Yes, we're ready whenever.
All right, we're not taking a plea now. I gotta break everyone for lunch. So let's reconvene at 1:15. And if we want to start with Jones, we can start with Jones. We can start, there've been people waiting out there. We can start whatever order, you and Ms. Dilligard or whoever the prosecutor is. And we'll just keep taking pleas. And eventually we've got Mr. Okoro, but that's not either of you. Okay?
You say you'll take it, Judge.
So I will be back at 1:15. In theory, we have Hall. I don't know what we're doing with Gill. We've got Jones. We've got Hill. Gill, Hill, Jones, Hall. All right. and maybe Mr. Jim Tao will get here. All right, Madam Court Reporter, you are free to be at ease and get yourself a break between now and 1:15. We'll pop back on. I'll shut everything down. I promise I'll turn the audio back on.
Thank you, Judge.
You bet.
No. Press that back. Not that we're on.
Other than you, Judge.
There we go.
Other than you, Judge, you see the biggest guy here.
Yeah. Okay, welcome back, everyone. I've been asked to try to do the Jones plea first, but I'm open if you all have told someone else they're going first.
No, I can do that, Judge. I did want to get one person out there, Mr. Ferguson, so just to kind of young out.
Okay, let's talk about that situation.
Yes.
He brought the phone.
Yes.
The DA's office has had a chance to look at the phone. Do we have answers from them, or they need to now digest what the phone contents means to them?
And speaking with Mr. Abadi, it looks like Miss Charles's investigator got what she needed,
Mhm.
so now they just need to.
They need to do their thing.
Yes.
Okay. Mr. Ferguson stays on the trial calendar. What's your sense? So we'll put it on the short list, but it's something that, based on the contents of the phone, may now resolve? Okay. Let me put that there, 19 Ferguson, and that's Mr. Ferguson right there. Okay, so Mr. Ferguson, Ms. Wood will keep you posted. I don't know how this is gonna play out, but you may need to come back. If you come back, it could be for an amount of time where it doesn't make sense to bring your daughter. So you may wanna, I don't know how easy it is, your child, your child is always welcome here and has been extremely well behaved, but there may be a time where you need to be up here, and if you're the only one, the deputies. Oh, someone else, okay, that's all. I just want to make sure your son is in good hands if there's a time where we all need to be interacting up here. So just stay in touch with Ms. Wood and she'll let you know what's going on. All right, you're good to go? All right, any other quick announcements?
Mr. Gill is gonna be a trial judge. I think he's back on the Zoom.
He is not, but he doesn't need to be. If that's where we are with it, I will slide him across. And that's not one where you had any issue being ready for the week of the 19th?
No.
Okay, that's our oldest one, but he's on bond, but so is Mr. Jintao. Did Mr. Jintao make it?
No, Judge. So his driver put down the wrong date, so he does not have a ride. I'm texting with Ms. Clark, because again, I was trying to resolve it. If there's something that we could do where he hopped on Zoom, I was trying to make that happen.
He's not in bond bench warrant risk right now, so don't worry, but he shouldn't worry about that, given his transportation complications. But he is on the short list. So was there something that changed such that Ms. Clark and you are closer together, or you've always been kind of close? I don't remember the history of this.
We are closer now because we've had a little bit more time to talk.
Mhm.
So that's why it's changed, but she needs to confirm some stuff.
Okay, she's got some work to do. All right, let's bring Mr. Jones out, please.
Thank you, Judge. We can get him back to Wright Street.
Mr. Jones also has a case for which he's on probation.
Yes.
We're tackling that as well.
Yeah.
Hold on right there.
You sent me something about? Oh,
Right there.
and she said yes? Good. Hello, Mr. Jones?
Hello, sir.
I'm all right. We're gonna get started in just a second. We're awash in deputies. This is great. If you had walked in a few minutes earlier, we'd have 4 deputies in here. Now we're talking.
It's gonna run concurrent to what's left on that probation.
Okay.
Okay.
Where's the one who went? Here yet?
All right, Ms. Dilligard, let me know when you are ready.
Ready.
All right. And Madam Court Reporter, you're back. I see you there. Thumbs up, ready to go. All right, this is position 20, State versus Kenneth Jones, 24 SC 005183. Mr. Jones, you are out here to enter a plea in your case. Is that correct?
Yes.
Okay, you also have an open probation case. I think we're going to take care of that at the same time.
Yes.
Ms. Dilligard's going to put you under oath. You'll need to answer her questions. I'll have a few questions as well. You might have questions, and if you do, will you let me know so I can try to answer them?
Yes.
Great. Ms. Dilligard.
Mr. Jones, can you please raise your right hand to the best of your ability? Do you swear or affirm that the testimony and statements that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You lower your hand. Can you please state your true, correct legal name for the record?
Right, Kenneth Lenard Jones. Kenneth Lenard Jones.
Mr. Jones, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you did not take today?
Well, my high blood pressure medication.
Did you take the high blood pressure medication this morning?
Yes.
When you take it, does it make you drowsy or woozy?
No.
No?
Use the restroom a lot.
Have to use the restroom, but that's keeping you awake. Okay.
Mr. Jones, how old are you and how far have you gone in school?
I'm 56. Well, I started at 10th grade, but got put out of school.
Okay. Is English your native and dominant language?
Yes.
Do you understand that you've been charged with the following offenses? It's 1 count of felony theft by shoplifting and a count of simple battery.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to those charges?
Yes.
Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer regarding this indictment to include the facts and circumstances related to the charges?
Yes.
Would you like any more time to discuss the case with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes.
Counsel, do you waive formal reading of the indictment and waive any and all defects for purposes of the plea?
We do.
Mr. Jones, do you remember having been arrested for these charges?
Yes.
Has your attorney advised you the minimum maximum sentence for each charge which you're pleading guilty to today? For the theft by shoplifting, the range is 1 year to 10 years. And for the simple battery, it's 12 months, 1 day to 12 months.
Yes.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the state's recommendation is 5 years to serve 1, commuted to time served, 100 hours of community service, and a stay away from the incident location.
All right.
Is that your understanding of the state's recommended sentence?
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that if there are multiple charges to which you're pleading guilty to today, that the court has the right to run those sentences consecutively?
Yes.
Do you understand that the court decides to order a sentence? That differs from the plea you were expecting today, that you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
Well, that probation, yes.
Here in Fulton County, he is.
Yeah.
Okay. You understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering of a guilty plea today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial.
Yes,
Is it your decision to waive these rights and enter a guilty plea today?
yes,
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
no,
Is it your decision to enter a guilty plea because you're in fact guilty?
yes,
How do you plead to the charges of theft by shoplifting and simple battery in indictment number 24 SC 005183?
guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes,
Do you understand that you only have a limited right to appeal this guilty plea conviction?
yes,
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
yes,
Do you understand that for a felony charge, you only have 4 years, and for a misdemeanor charge, you have 12 months from today to file that petition?
yes. So yes.
Okay. Judge, if this case were to proceed to trial, the state contends that the evidence will show that on Wednesday, May 22nd of 2024, officers were dispatched to the Exxon gas station in regards to a criminal trespass. Upon arriving on scene, officers met with Mr. Debashis-Data, who stated that throughout
You want to spell that for the court reporter?
My apologies. DEBASHIS-DATTA. Who stated that throughout the day, Mr. Jones had come into his establishment and stolen a 12-pack of Michelob Ultra beers. During the encounter, Mr. Jones and Mr. Dada stated that Mr. Jones pushed him in the chest with both of his hands and also open hand slapped him in the face. He did not have any visible injuries. Mr. Dada provided officers with video footage of Mr. Jones walking out with the 2 cases of Michelob Ultra beers. Officers were able to locate Mr. Jones next door at the Ideal Sports Bar with the 2 cases of beer still in his possession. All of this occurred in Fulton County, Georgia. Judge, the state is aware of a pretty lengthy criminal history for this defendant.
I have a repeat offender notice filed by a colleague of yours that lists 10 convictions dating back from 2019, well, older than that, 2012, 2010, some old stuff, and then something from 2020. Almost, many of them are shopliftings.
Yes, Judge.
Okay.
And so when speaking with my supervisor and counsel in this matter, I believe Ms. Wood has him lined up to go into PAD. And I can't make that a condition of probation.
Right.
But he will be receiving services through them. Also taking into account that he's been in custody for, this is probably not accurate anymore, but when I last looked.
351 days today. Okay.
Also taking into account the items that were stolen. So that is everything from this.
Okay. Got it. Ms. Jackson, can you share with me the 3 most recent cycles for Mr. Jones, please?
Okay, let me pull that case back up, Your Honor. Just a moment, please.
404.
Okay.
551. 06. 21.
What's her name?
Kimberly Condell.
Okay, thank you.
Okay, Your Honor, the most recent is 56 cycles. Was made at 22nd, 2024 with the City of Atlanta Police Department for simple assault and theft by shoplifting. They're both a misdemeanor. Prior to that, he was arrested October the 20th of 2020 in Fulton County for a probation violation. And prior to that, he was arrested September the 5th, 2019 in Fulton County for a probation violation.
So it was Between October of 2020 and May of 2024, no cycles.
No, Your Honor.
Okay, thank you so much.
Yes, sir.
Ms. Wood.
Thank you, Judge. Mr. Jones is 56 years old. He is a lifelong Atlanta resident. He was actually in a rehab program in Cartersville at some point before this arrest. And I don't know what happened there, but they are now shut down. So he made his way back to Atlanta, and that's what happened here. You heard he's been in 351 days. We are working with PAD. As soon as I get that release date, I'll get it to your court, to the court for a transport order. We're just asking that you accept the state's recommendation. I would just ask, since he was unemployed and in rehab before, and he'll have to work to get back on his feet, that you would consider waiving the probation fees for a few months once he gets out.
Okay. Mr. Jones, what's an example of the type of work you've been able to do?
I do carpenter work, and I was working in I was driving forklifts.
Okay. Do you have a forklift certification? No, you just sort of.
Everybody at the job I was at was driving forklifts.
Okay,
So,
that's all good. Just curious.
yeah.
Is Mr. Jones someone for whom you explored drug court?
We did not explore drug court, Judge, just given the fact that he had been in so long, and it was fairly easy for us to get him hooked up with PAD.
Okay. Mr. Jones, do you have any questions about anything anyone's discussed?
Well, yeah. So they're the same probation. They were talking about I go tomorrow to court for that probation.
If not, you don't have to. Well, let me find out. You think you have court tomorrow for your probation situation?
Yeah, that's right. I think it's the same probation y'all.
Let me look. You do. You have a hearing tomorrow, but I'm taking care of it today. So we'll handle that. Do you have other questions?
I can't think right now.
Okay, well, if something comes up while we're talking, let me know. Mr. Jones, Ms. Wood said you had been in a rehab program up in Cartersville. What were you working on? Your addiction is to what?
Alcohol and cocaine.
Alcohol and cocaine? How many days or weeks or months had you been in the program?
I was in that program probably about a good 6 months, maybe.
Did they provide housing for you?
Yeah, I was paying rent and everything.
Okay. It was going well?
No, that lady, she was stealing my money.
Oh, maybe that's why it shut down.
Yeah, because the probation, I tried to get my probation transferred down there, and they denied my probation. So I was like, I said, where am I go, man? They said, well, you got to leave that program because they're under investigation.
Okay.
She was stealing.
Okay. Got it. Well, PAD is not going to steal from you. Mr. Jones, I find there's a factual basis for your plea. About a year ago, you were at Exxon, took some things that didn't belong to you. You had them right next door when the police showed up. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea, and knowing means that you've understood what we talked about. And if you didn't, you ask questions. Any other questions right now?
No, I just want to say I feel real bad what I did.
Okay.
I'm really trying to get y'all attention. I went to the probation and they wouldn't do nothing. So
get our attention to do what?
It helped me. I'm tired. I'm tired
Okay.
of being out there in the streets.
Well, let me tell you, hopefully, if you engage with the folks from PAD, they're going to offer you services and support. If that doesn't work out and you get picked up again, you're going to come back and see me for this case, and I will likely refer you to the intake people from our drug court to see if your participation in drug court would make sense. I get it why we're not doing it now, but if PAD doesn't provide you the help you need and you do something that's another plea for help, then we may try out drug court, assuming that they accept you into the program, okay?
Yes.
We'll see what happens. I'm sentencing you pursuant to the Probation Options Management Act, which means while you're on probation. If you have a technical violation, you and probation will solve that problem. But if you get arrested for something else, that comes back to me. Ms. Wood, can someone in my office sign the indictment for you?
Yes, sir.
Ms. Dilligard?
Yes, Judge.
And Mr. Jones, is it okay if we electronically sign your name to the indictment indicating your guilty plea?
Yes.
We'll do that. It sounds like no restitution. It was some beer and they got their beer back, or almost all their beer back. All right. Did you drink any of the beers?
No.
No. Okay. Did you sell any of the beers? You just had the beers. Were you just going to admire them, or at some point you were going to drink them? Who knows? It didn't last that long.
Got really burnt down on Bill.
Ms. Wood, are you waiving any due process notice rights Mr. Jones has concerning the probation revocation?
I am, Judge.
Okay. Is the petition, it's not in the docket for the 18 SC case, but Ms. Simpson, is the basis for the upcoming revocation, the calendar tomorrow, is that for these charges or something different? They were all technicals?
Yes, Judge. Which is why, I told Ms. Wood that whatever, your sentence was for the new charge, it would coincide with the revocation.
Okay. How much time remains on the 18 SC case?
He has 3 years, 10 months, 6 days.
All right. And I interrupted you. The technicals were?
He made contact, on January 30th, 24 with the victim of that case, as well as he moved without notifying his office.
Okay. It's a shoplifting case, so meaning he like went onto the premises?
All it says is he made contact.
Okay. I'm gonna look at the final disposition just so I can better understand what that's.
And he was supposed to complete perjury recovery.
Okay.
I found that program myself.
It says cannot go to any CVS store, so maybe he went to a CVS store. Still can't go to CVS. Try Walgreens, okay? No CVS. My guess is Walgreens don't want to see you either, but if you got to go to a drugstore, go to Walgreens and not CVS. So Mr. Jones, on count 1, I'm going to sentence you to 5 years to serve 1 year with the balance on probation. Count 2 will be 12 months to serve. It'll run concurrently with at the same time. You've done 351 days of the 365 days, so you're that close. If PAD opens up between now and then, I'll get you out anyway. But if not, you will be released, and I encourage you to go to PAD. They're a walk-in place, and you should, if you are interested in getting help, don't walk to a CVS or to that Exxon station. Get to PAD and let them help you. You will need to complete 100 hours of community service. That's a lot, but you got 4 years to do it, so spread it out. You need to stay away from that Exxon we're talking about. Just like these CVSs, no to any CVS and that one Exxon. I will waive your probation supervision fees for the first 6 months while you get back on your feet and get to work as a carpenter or whatever it is you're going to do. In light of those technical violations I heard about, where maybe you went back to a CVS and you didn't complete the program that you found, what I will do is, I guess what I'll do is revoke 5 months, but give you credit for the 351 days you've been in. So you've already done those 5 months, and then reinstate the balance. So you're going to be on probation in 2 cases running at the same time, just one probation officer, this new one, and the 18 SC shoplifting from the CVS. Does that make sense? You gave me a face that means it doesn't make sense.
From the CVS.
From their older case, is that?
The older case, the case you're on probation for now.
Yeah.
Yeah, that probation is going to be running at the same time as your new probation. Okay, so it's 2 probations, but at the same time, 1 probation officer.
Okay.
Do you have any idea where you might be staying when you get out? No? Then you're going to get reporting instructions from Ms. Simpson, but it's going to be along the lines of within 48 hours of getting out. You're going to get out between now and 2 weeks from now. I can't give you the exact date, but when you get out, it either will be because you're being transported straight to PAD, which is good. That's the best way we're going to get you out. But within 48 hours of getting out, you also need to go to the probation office. You know where that is?
Yeah.
Where?
Yeah, right down the street.
Down the street. That's exactly right. Any other reporting instructions? Look at that, I did it. All right, so 48 hours after you're released. Ms. Dilligard, anything else in Mr. Jones's case? Ms. Wood?
No, Judge, thank you.
All right, Mr. Jones, good luck.
Okay. All right. Good luck to Mr. Jones.
Thanks.
What's next, Ms. Wood?
Cameron Hill, Judge.
All right, Ms. Clark, I don't see Mr. King or Ms. Kim yet, so I'm assuming they're on their way. Mr. Okoro was here. Is he talking to his lawyers? They're here. Oh, okay. All right, well, we're gonna take another plea and then we'll talk shop about what we're gonna do with the motion. What did you say we're doing next? I'm sorry, I got distracted by, Okoro.
Position 21, Cameron Hill.
Mr. Hill, all right. There he is. Hill. Ms. Dilligard, are you ready?
Yes, Judge.
Yeah, good pivot. All right. Mr. Hill, are you ready?
Yes, sir.
We're about to go on the record in your case. Once we're on the record, you'll be asked a bunch of questions. You now sat through a couple of these. It's going to be similar to what you saw, okay?
Yes, sir.
Let me know if you have any questions.
Yes, sir.
All right, this is 24 SC 005244, State versus Cameron Hill. Mr. Hill is here in court with his lawyer, Ms. Wood. Ms. Dilligard is representing the state. Ms. Dilligard, when you are ready.
Mr. Hill, can you please raise your right hand? Do you swear or affirm that any statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct legal name for the record. Mr. Hill, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you have not taken today?
No.
You had to think for a minute.
Like pain medicine.
Okay.
I got like nerve damage and stuff like
Okay,
that.
but you're taking like over-the-counter stuff like Tylenol, or you have a prescription that's like an opiate?
That in the store.
I could just walk into the store and buy what you're taking?
Yes.
Okay.
Mr. Hill, how old are you and how far have you gone in school?
21 and I graduated.
Where'd you graduate from?
Martin Luther King. That's and I guess Stonecrest or Latonia now. They changed the city limits.
Okay.
Do you understand that you've been charged with the following offenses? It's 1 count of theft by receiving stolen property, a count of possession of a machine gun, felony fleeing and attempting to elude, reckless driving, and willful obstruction.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about the charges in this indictment, including the facts and circumstances related to the charge?
Yes, ma'am.
Do you need any more time to talk with your lawyer?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment and waive any and all defects for purposes of the plea?
We do.
Mr. Hill, do you remember being arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge which you're pleading guilty to today? For count 1, theft by receiving, the range is 2 to 20 years. Count 2 is 5 years. For count 3.
Is it 5 years consecutive? It's just a 5-year
It
sentence.
says 5 years.
Plain old 5. Okay.
For count the fleeing and attempting to elude, it's 1 to 5 years. I mean, we're actually amending it to obstruction, Judge, and that range is 1 to 5 years.
Count 3 is.
Yes.
Okay.
Count 4, the reckless driving is 1 day to 12 months, as well as count 5 is 1 day to 12 months. You understand that?
Yes, ma'am.
So there's a misdemeanor obstruction, that's the running, and then there's a felony obstruction, and that's the driving.
Correct.
Okay.
Do you understand that today you're entering a negotiated plea, which means that the state will recommend the following sentence to the court? Judge, the recommendation, as just stated, we are amending count 3 to felony obstruction pursuant to OCGA 161024B. The sentence is 8 years to serve 6 months. It's 150 hours of community service and to complete TVIP.
TVIP.
And-
All right.
I'm sorry, Judge. I just remember because we changed that at the last minute.
Yes.
So we didn't fully go through that. I don't think it'll blow anything up, but if Ms. Dilligard would just kindly explain.
Yes.
What TVIP is? Sure. It has to do with not being a dangerous driver, but I'll let her tell you more about it.
So originally we were going to have Mr. Hill, we were going to do weekend jail, but he opted to do the straight time. When he was going to do weekend jail, we were going to have him, if Mr. Poole was going to go to trial, for him to sit through Mr. Kenneth Poole's entire.
Oh, but that's not a condition anymore.
Not because-
It'll be TVIP instead.
Yes, because we were I think you, Your Honor, mentioned maybe Poole going this summer, and so he would still be in custody.
Okay. Did you know, you don't know Mr. Poole himself, but did Ms. Wood tell you about what that case is about?
No, sir.
Okay. Guy drove way too fast on the off-ramp for Lenox exit 2 on 400 and just T-boned into this wall. The debate is who was driving, but whoever was driving was going way too fast, being pursued by a highway patrol guy, and 2 passengers or occupants died. The trial is about who was driving, not about was it reckless. It was clearly reckless. To a zillion miles an hour into a cement wall. Unsurprisingly, lots of people in the car didn't do very well. And so watching that trial would be an eye-opener about what can happen when your situation ends even worse than your situation. Neither here nor there.
And so traffic violators impact program, it will achieve similar goals. It's a program, it's a class that you would take instead. Okay, so is that your understanding now of the recommendation?
Yes, ma'am.
Okay, great. Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that if there are multiple charges to which you're pleading guilty to today, that the court has the right to run those sentences consecutively?
Yes, ma'am.
Do you understand that the court decides to order a sentence that differs from the plea you were expecting? You had the right to withdraw your plea?
Yes, ma'am.
Are you currently on probation or parole anywhere?
No, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes.
Miss, what is he doing first offender?
Yes.
Okay. Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you ever pled guilty to a felony in the state of Georgia?
No, ma'am.
Have you ever pled guilty to a felony in any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
Yes, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status can be revoked?
Yes, ma'am.
This means that you can be adjudicated guilty and you can be resentenced up to the maximum sentence for each charge in this indictment. Do you understand?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes, ma'am.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you're in fact guilty?
Yes, ma'am.
Mr. Hill, how do you plead to the charges of theft by receiving stolen property, possession of a machine gun, fleeing and attempting to elude, reckless driving, willful obstruction misdemeanor, and indictment number 24? Oh, excuse me. I think I said felony fleeing. So the felony fleeing is being amended to felony obstruction. And then there's a misdemeanor obstruction. And indictment number 24 SC 005244.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
You understand that for a felony charge, you only have 4 years, and for a misdemeanor charge, you have 12 months from today to file that petition?
Yes, ma'am.
Judge, if this case were to proceed to trial, the state contends that the evidence will show that on December 26, 2023, officers were alerted to possible narcotics activity at the BP gas station located at 3004 Piedmont Road. When officers arrived, they witnessed the passenger of Mr. Hill's car, later identified as Mr. Johnson, do several hand-to-hand transactions, one with a passenger inside of a white Lexus. The passenger then went inside the BP gas station and returned back to the vehicle that Mr. Hill occupied several times. Mr. Hill was then observed moving the Jeep around the gas station several times throughout this entire incident. He finally then drove off of the BP property southbound on Piedmont. Officers attempted to do a traffic stop on the vehicle. The vehicle then began changing lanes without signaling. The vehicle then slowed down and officers began to approach on foot. The defendant then drove off recklessly at a high rate of speed, changing multiple lanes. The officers indicated that it was heavy traffic and the roads were wet from recent rain. The officers then observed the defendant's vehicle strike several vehicles at an intersection. The defendant then exited the vehicle and fled on foot. He was later detained. The tag on the Jeep returned to a 2003 Nissan, which was stolen out of Alabama. And during an inventory search of the vehicle, another license plate was found in the rear seat along with 2 firearms, one that was equipped with a switch, making it fully automatic.
Do you know if the license plate that was inside the Jeep went to the Jeep?
It says another Georgia license plate, so.
Okay.
I don't believe so. I believe that is all I have. I'm not aware of any other felony convictions for this defendant. I did want to indicate to the court that at the last hearing, spoke with counsel and her client, and he was very remorseful, was ready to plead to the charges and take the year. He was very apologetic, came across something I had not encountered yet. And so taking that into account and the fact that he was taking care of I believe an elderly family member and working hard is how we came to the negotiated plea to amend the charge.
Okay. Ms. Jackson, do you have any criminal history information for Mr. Hill?
There are 2 cycles. The last arrest was May the 10th, 2022 in DeKalb County for misdemeanor obstruction of an officer. That charge was null pros on November the 27th, 2023. Nothing in addition, Your Honor.
Thank you. Ms. Wood.
Thank you, Judge. Mr. Hill is 21 years old. You heard he is a high school graduate. He is gainfully employed. We spoke with his employer who characterized him as an outstanding employee. He works at Foamworks Car Wash. He also does take care of his disabled grandparents. He's also helping his mother, who is here in court today. He has some other family members that are also here in support. Judge, as Ms. Delegard stated, he's been eager and willing to accept responsibility The reason we pushed it further is to continue negotiations and also give him time to line everything up before he goes into custody. Judge, I would ask that you consider waiving probation fees for a period of time once he is released. We are asking for first offender treatment, and I would also ask for a behavioral incentive date.
All right. Mr. Hill, you've been helping take care of one grandparent or two grandparents?
Two.
Grandmother and grandfather?
Yes, sir.
Okay, on your mom's side or your dad's side?
My mom.
And what does it mean that you're helping to take care of them? What were you doing?
My grandma has MS, so she, walking. And my granddad, he has pretty much leg work, bad veins, and he just got eye surgery. So I take them to doctor's appointments and pretty much that. I go to work in the morning to try to stay, positive and
Sure.
I work in the morning and I take them to appointments and
Then you're sort of transportation for them.
I'm the only one that stay at the house.
You stay at the house too?
Yeah, it's just the three of us.
Oh, so they have their own house and then you're sort of in-home care.
Basically.
If they need something from a cabinet they can't reach, you're doing that?
No, a little more than that. I literally, I don't want to say they handyman, but I literally do everything.
Okay.
Like, I cook some nights.
Okay. I didn't mean to minimize it, but anything they need, you are helping them with it. Except
sir.
if someone needs surgery, you're not sewing up their arm.
That, but as far as I help them with putting races and taking them to appointments because they can't drive certain stuff. Like that.
Okay. And Foamworks, it's a car wash?
Yeah, it's right around the corner.
From where your grandparents live?
Yes, sir.
Which is where?
Ellenwood, Georgia.
Okay. I spent the last 2 weekends at Morrow High School. My kid had baseball games there, so I now know how to get to Ellenwood from Atlanta. It's not close. Okay. Do you have any questions about anything we've been talking about?
No, sir.
Okay. Well, it sounds like from what Ms. Dilligard experienced and expressed to me that you get it in terms of the changes you need to make. It may have been kind of exciting and better and quicker money rolling with whoever that was in that Jeep, but it's dangerous, it's risky, and it's going to have the consequence that for the next few months, you're not there for your grandparents. And I'm sure they get it, but that's on you. But you also have a whole bunch of years ahead of you. And so I'm hopeful that this is a one-time thing. Let me tell you a little bit about first offender because you qualify for it. And it's a great opportunity because it keeps this case off your record. If you are trying to go back to school or get a different job, you don't have to check the box that says I'm a felon because you're not. You're just going to be under sentence until you're not under sentence if things go well. That's the benefit. You can get it expunged and sealed, and it's almost like it never happened. Of course, it did happen, but for people outside your life, they don't need to know about this. Here's the risk, and the part I want to make sure you thought long and hard about. If, while you are under this sentence, you just can't resist getting back with that crew or people like that, and you get arrested again, drugs, guns, doesn't really matter what it is, that new set of charges will come here as a reason to revoke your probation and take away your first offender status. We have a hearing, your lawyer could help you, but if I found that you did that new thing, whatever it is, I could and might, resentence you because you've already pled guilty. And you heard all those big numbers that Ms. Dilligard was using. If you add it all up, it's 31 years. And so I'm not saying I'd sentence you to 31 years, but I am saying this. If you get arrested in the next year and you got a gun on you or near you, in the console, in your house, wherever it is, I'm going to take away the first offender status and you're going to go away for a while because that's a sign that this didn't change your trajectory. And you don't have kids yet?
No, sir. Good.
But you're going to have kids sometime and they need you around and not rolling in this Jeep, going fast, crashing, running, getting arrested. So I just want to make sure you understand this risk to first offender. If you screw up, and it's not hard to screw up in this world, there are temptations and maybe you lose your job and you're just going to do a quick hustle here or there. If you screw up, this could come back real hard at you. Do you feel like you understand that?
Yes, sir.
Do you still want to be sentenced as a first offender?
Yes, sir.
Okay. Well, it's your choice. So I will sentence you as a first offender. So Mr. Hill, I find there's a factual basis for your plea. It's pretty clear what happened here. I also find that your plea is knowing and voluntary, meaning you've understood what we talked about and no one's forcing you to enter this plea. I'm sentencing you pursuant to the Probation Options Management Act, which means that if you have a real small problem on probation, you miss meetings, or maybe, I'm not saying you do this, but if you tested positive for marijuana or something, probation will work with you on that. But if you get arrested for anything, that comes back to me. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Dilligard?
Yes, Judge.
And Mr. Hill, is it okay if we electronically sign your name to the indictment?
Yes, sir.
There's no restitution here that you're aware of. The stolen Jeep crashed, but
No restitution that I'm aware.
okay. All right. Well, Mr. Hill, here's your sentence. Count 1 is 8 years to serve 6 months. Count 2 is 5 years to serve 6 months. Count 3 is 5 years to serve 6 months. And counts 4 and 5 are 6 months to serve. Those will all run together. So the overall sentence is what your lawyer negotiated for you, 8 years to serve 6 months, balance probated. You've done 6 days already. So you have 5 years, 5 months and whatever that is, 20 days, 25 days left. I don't know if you'll go into the state system or not. Probably not, because that's a pretty short sentence, but no one is guaranteeing anything like that. You might get released before you do the 6 months. The most you would do is 6 months minus 6 days. When you get out, you'll be on probation. Special condition number 1 is that you will complete 150 hours of community service. And I'm going to require that you've done at least 50 of them during the first 6 months of your probation. So we don't have something where, man, it's getting to the end of probation, you still have all 150 left. Special condition number 2 is that you complete the TVIP program. That's this driver safety and just getting you pretty sober about the risks of reckless driving. I will waive your probation supervision fees for the first 3 months, because when you get out, you may not still have that job at PhoneWorks. You're going to want to find a job. You may be able to go straight back there, but the first 3 months, you don't have to pay those fees. And I'll set a behavioral incentive date of May 9th of 2028. That's 3 years from now. That means that if you've done everything you needed to do and there have been no significant issues with probation, they can come to me to say, let's close this out. He's doing well. You'll be almost 25 by then. And if there have been no issues, you have demonstrated, most importantly to you and your family, but also to those of us who care and have been watching, you're a different guy and you're heading in a different direction. And that'd be great. I'd be happy to end your probation early. But remember what I told you, if probation is rocky because you're back to the old Mr. Hill ways, I have a lot of time to work with on this sentence to say, well, we have to try something different to get through to you. And that might mean going down the road for a long while. And no one ever wants to do that, but you can force our hand depending on how you handle life on probation, okay? Mm-hmm. And again, I'm sentencing you as a first offender, so it's not a conviction so far. Any questions about any of that?
No, sir. Thank you again.
Well, you can thank me by, I see you outside this courtroom next and not inside this courtroom, because I come by wherever your business is and do business there. Legitimate business. You're going to be living in Fulton County when you get out?
No, sir. I'm going back to Ellenwood.
Oh, Ellenwood. So that's a faraway county. That's all I know, because it was long. What county is that?
That's DeKalb still.
That's DeKalb? That was so far away? There's no way that was DeKalb.
It's about 4 different counties.
Oh. Okay. What part of Ellenwood are you in? Which county?
I'm right there on the line with all that. That's the crazy part about it.
Or you've looked it up already? She's done her homework. Okay. Based on your address, you will be reporting to probation in DeKalb County. Bad news for you. That office is in Conyers. But you don't have to go there every time. The first time you report to probation, you'll go to Conyers, so you meet your officer, whatever you need to do. You'll have to report to probation within 48 hours of getting out. So when you are released, go home, hug family, check on your grandparents, and then in that next day or so, you got to hoof it out to Conyers to say, here I am, it's Mr. Hill. and then you'll be under supervision and start doing these other things. Any questions?
Do I get this information when I get out? Will I, or
Will he also get it when he gets out, or who's gonna?
if I get it right now, then that's cool. I can put it up on ice, but I just know I need to have it.
You're gonna get it now so you can put it up on ice. Because I don't know exactly what they tell you when you get out. It's pretty much here are your clothes.
Yeah.
Bye-bye, and that's it. So, anything else, Ms. Dilligard?
Nothing further, Judge.
All right, Mr. Hill, good choices going forward, okay?
Yes, sir.
Oh.
She said,
She's coming back there.
Here. Thank you, Judge.
You're welcome. Mr. King, how are you? How's your dad?
He's recovering.
Good. Excellent.
Thank you.
Glad to hear that. You are here along with your client and Ms. Clark because we've got the 414 motion. And we will do that. I think I have one more plea, but I just wanted to check in because I know you and Ms. Clark have been talking some. We're still going forward with the motion or something different happening?
I was gonna ask you something just different, Judge. I need more
A
time.
dismissal?
Well, I'll ask for it, but
Yeah.
realistically, I just need some more time to investigate this matter. Got the motion, 404 and 414.
Mhm.
Got it on Monday. Everybody's out of state. The state is invoked, which is their right to defense counsel not to be able to speak to anyone. So. I'm really trying-
So we're clear, it's not to speak to anyone, but the key witnesses.
The ones that we're speaking about.
Right, there may be an uncle or an aunt or someone you could talk to, but the alleged victims of these other situations, that it sounds like they have said, they don't want to talk to you, other than if they come to court and have to testify.
You know, I respect that.
Yep.
So the 414 witnesses, one from 2006, one from 2007. Case in chief of the outcry was 2 years, 2.5 years after the incident. So there's things that I believe would be strengths in our case. And after this case has kind of been going through the pipeline, then I get this 3 days from now. And then it's not a criticism, because this is how things go sometimes.
Right, I suspect.
Me in a place where I gotta work, and I would ask to be able to do that work before two things, before us doing the motions and before trial. And I know the state served some new discovery on me. I think there was 11 new items on Friday. I still really haven't looked through that. So that would be what I'm asking for today.
What did you just get? What's the new discovery?
I don't even know that, because he pointed it out to me today. I didn't realize that I got it. It came through Axon, and I didn't realize it because it came from Ms. Clark. Well, it had her name in it, but she had just given me something in March. So I didn't realize there was an additional set.
Okay.
And so then when she pointed it out, there was 11 new things. So I don't even know, because that's what she pointed out.
Okay. Ms. Clark, what are the new things?
Your Honor, so the new things, I guess, would be the 413, there's a police report, that was provided. There's a sworn statement from the victim, from that 413 case. And I think there are a couple of photos.
Does all the new material relate to your motion as opposed to the case in chief?
Yes, Your Honor.
Okay, so it's.
I'm sorry, the only thing that's different is there's like a incident sheets that the investigator in this case is not really an investigative report. It just is like more of a timeline. And I actually just received that, and when I received it, I just went ahead and sent that as well.
But that timeline, that's from the case in chief.
Right.
The other items that Mr. King just recently received would relate to the other act's evidence.
Yes, Your Honor.
Okay.
And I wanted to, when it was brought to my attention about the 414 witnesses, the other witnesses, I wanted to do my due diligence and interview and scrutinize these witnesses to ensure before I made a filing. And when I did, so that's why I filed it.
Is this the case where you have a couple witnesses who are medically quarantined?
Yes, Your Honor.
Have you and Mr. King, we don't need to talk in public a whole lot about what their situation is, that they're quarantined. Have you and Mr. King talked about the logistics of how that would work if we went to trial soon rather than, how long does the quarantine persist?
So it's my understanding just from reading on Google that like if someone has tuberculosis, that there's like up to a 9-month period where they're supposed to like stay away from people, and for sure they can't travel.
Okay.
On planes or anything like that.
They would need to use personal transportation, that's for sure. They're far away?
Yes, Your Honor. They're live in New Jersey.
Okay. Do we know how far into, let's assume for a minute it's 9 months, and we'll have to get the actual medical answer, but if it's 9 months, how far into the 9 months are they?
Now that I don't know.
Okay.
I think I was so in shock and awe to hear an actual person today that has TB. So I was like, I think I kind of didn't even ask that part.
Mr. King, do you have at this point, it's not your final answer, but a tentative answer about your willingness to have those witnesses testify virtually rather than in person?
Yeah, my answer is no, Your Honor.
Okay.
I can't remember, it's been a long time since I've had this, a couple of years, but.
Since you've had TB?
I can nudge it. Since I've had this issue come up.
Oh, where someone needs to.
Right, and I can't remember if I have to consent, but we're definitely not consenting.
You don't have to. It just means that it's a continuance effectively at your request, but your client's on bond, so no one's in a trick box here. Where that gets complicated is if your client were in custody, then there's that maybe unhealthy pressure to say, all right, well, I don't want it, but I'm gonna let him testify virtually because my guy's stuck in custody. So there's at least a little wiggle room here. The charges continue to hang over your client's head, but absent some pretty extreme findings on my part, a continuance is what we'd need to do. Which means we certainly have time to reset this motion and hear it at a later date. Ms. Clark, can you make an inquiry of the two people about whom we're speaking to see what they are hearing from their doctors? Because I'm sure they are anxious not to come down here, but to be out of the quarantine. And so they ought to be able to tell you, yep, it's 3 months, 2 weeks, and 1 day, or however long it's going to be.
Yes, sir.
And then if you could let Mr. King and me know that, that'll help. And then I will work with your schedules, plural, about resetting the other acts evidence hearing. We won't do it right away, but is there any reason why if it were a month out, that's not enough time for you?
Judge, the only thing, I mean, I got to brainstorm about what exactly I want to get. My client was in and out of the military as far as active duty at the time. So there are some specific dates that I would like to gather. I doubt that would take a long time. And then the other thing is that I always object when there's never been any allegations made, no indictments, no warrants or anything like that, and to not being able to cross-examine the person. Because in my opinion, once you put them in trial, because I know the case law says the judge rules that a 404 can come in and I can cross-examine them, but I can't unring the bell at the time of trial. So I always object, and I know you will, however you see fit. But I know that I will object for the state presenting a proffer to this evidence because there was never an outcry. I believe the police report in one of them came from 21 because the state has given me a police report number and it has 21 at the beginning of it. So my impression is that police report came after this allegation. And so I I don't think it'll be longer than a month
Okay.
for me to make this argument that I'm making right now, but obviously the factual specific argument.
Okay. Well, my understanding of the case law as it exists now, it's being challenged. One of my colleagues has challenged it. I don't know if the defense attorney is taking it up, but if the defense attorney objects to a proffer for other acts evidence, then I'm required to have that witness or witnesses testify, so that I'm finding that there is a sufficient basis, and it's preponderance of the evidence. It's not beyond a reasonable doubt, so it's much less, but that we'd need to do that. So we'd need to be much more thoughtful about what date we set this down for, because we'd need to have any number of witnesses that Ms. Clark thinks needs to be here, and at least 2 alleged victims. I think they're adults now. So I'm a little less concerned about putting a 8-year-old who's now 9 through a trial twice by basically doing the other acts hearing and then testifying at trial. So while it's not going to be easy testimony for anyone involved, we've got folks who should have more emotional durability for that hearing. It just means the hearing is going to take longer, but I think the case law is right now, if you object to a proffer, and the proof would be through testimony, not a certified conviction kind of thing, which is not this situation. It would be the testimony of, here's what happened to me, or here's what my daughter told me, that kind of thing. Those folks need to come on in. So I will get with Ms. Nelson and we will think about a date for a half-day-ish type thing, but it would be at least a month out.
Thank you.
Okay, anything else we should know about your planning for this case? I don't mean what's your strategy, but I want to make sure we aren't setting a date and then you show up saying, you didn't give me enough time for whatever it is.
I don't think so, Your Honor. Just like I know Ms. Nelson does all the time, she will reach out and just, but I don't think so. We don't have some leads coming up, but.
Well, those, if they're in the docket, we navigate around those.
Yeah, but no.
Okay. Ms. Clark, the witnesses that you would need to call for the other acts hearing would be coming from where?
Chicago, New York, and
All domestic.
yeah, they're all domestic. Nobody's international.
Okay.
But I also just wanted to add, Mr. King indicates about the fact that no police reports were filed. In this particular case, Your Honor, the witnesses actually, they were all victims. And they actually, when finding out about their younger cousin being molested in the same way, feel bad because they remain silent.
Got it. And that's not an uncommon storyline. So I get that. And all I heard Mr. King saying is interesting, because the police report documenting outcry for one of the other acts postdates the alleged conduct in the case in chief. To me, that's not remarkable. We have cases all the time where something comes to light and other people say, it's not safe for me to bring this up, or I'm ashamed that I didn't. If I had, I might have saved my cousin. I mean, not providing the real narrative, but that may well be. And that's something that Anique Whitmore or someone would explain to the jury if this gets to a jury. So I think that's what we'll do. I know we'll reset this to have that hearing. And Ms. Clark, you'll get back to us. As long as you have that information for when we have the hearing, when the quarantined people will be not quarantined, then we can map out a trial date.
And Your Honor, so you have for your records that the 2 witnesses that are under quarantine, Isabella Amaya and Gloria Martin. They were both at the time, at the case in chief, they were actually in the room.
But one is sister of?
One is sister.
You told me.
One is mom.
Yeah.
And they both, when the victim disclosed to them, they both were present.
Okay. But the alleged victim is not in quarantine.
No,
Okay.
she's in the she lives in Kansas in the military.
Okay. A lot of military in the mix with this case. Okay. Is Ms. Kim co-counseling with you?
Yes, sir.
As long as we're communicating with you, you'll manage her schedule. We don't need to juggle 2 sets of leaves.
That's fine. We talk almost every day.
Good. Okay. All right. If there's nothing else, then Mr. King, on behalf of your client, you and he are free to go, and we'll work on locking in a good window of time for the other acts hearing.
Yes, sir. Thank you so much for your time.
You bet. Same. All right, Ms. Wood, and Ms. Rios is back. That's great. What's up? Okay. There were windows of time when you were not here. But
in the back doing my work.
excellent. Well, what did that work yield? We still should have, where's my magic list that was shrinking a little bit? Mr. Hall? What are we doing with Mr. Hall?
I have been informed he would like a different attorney.
Oh, well, why doesn't Mr. Hall come on up here and we can talk?
Mr. Hall makes a nice program.
Mhm. Doesn't list any. Okay, and yet there's this cruise. Interesting. Thank you. It doesn't have that. Weird. Okay, is your sense that there is a much larger gap than was being broadcast? Okay, I mean, Ms. Charles did share that now there's someone saying, technically, if you were in a certain way, you could do what happened to yourself. But that hasn't led the state to say, how about 5 years? Okay, that's not the sense you'd get if you were listening. Okay, thank you. You bet. Mr. Hall, tell me what's going on. Well, first, you are charged with fleeing and attempting to elude and reckless driving and a window tint violation. So 1 felony, not a particularly serious one, although it has some sticky penalties, and 2 misdemeanors. You're on a trial calendar, and now all of a sudden you want a different lawyer. Are you going to hire a lawyer?
I was trying to see if I can get time to hire a lawyer.
Okay. You were arrested for this in 2021. So 4 years have rolled by and you didn't hire a lawyer during any of that time.
Yes, sir. Yeah, the case was kind of old, but I didn't know it was gonna come up this fast with the trial date, straightforward trial. I ain't have a preliminary hearing or nothing.
On your docket up here, we're going to talk about this because nothing is new about this case. Oh my gosh, the arrest was in 2019. So nothing other than your driving has been moving fast in this case. That's 6 years ago. And you didn't get arrested till 21. I don't know why it took 2 years for you to get arrested. You bonded out. You got indicted in April of 22, so your indictment is 3 years old. You missed court probably because your address changed, not your fault. And then we set aside the bench warrant. You were back. Case went to non-complex, where it should have stayed. It came here. So tell me what's been sudden here. Your case moved real slowly. It's from 2019. It's probably the oldest case I've seen in a bunch of weeks.
Yeah. If you go all the way back to then, yeah, it's kind of old. But now it's from the day when I got to the court, from time when I got the warrant took off of me.
Yeah.
To now, it's been a couple months.
No, your bench warrant was voided in October of 24. So that's 7 months ago.
7 months.
7 months. You waived arraignment in probably for the second time, but at least in this court before Thanksgiving. My scheduling order went out before Thanksgiving.
What is ready to rain?
It just means that Plea did not guilty. But my point is, there's nothing new about this, and we're here, and it's trial time. If you think you can hire a lawyer between now and trial time, you should go for it. But you have a very good lawyer who is currently representing you. A new lawyer is not able to squeeze a different offer out of the state. If you're frustrated because the prosecutor is offering this and you want this, it doesn't work that, all you need is a different lawyer, and that lawyer is going to say, please. Oh, if you had just said, please, I'll give you a different offer.
I'm trying to get a better understanding of everything. I just kind of not getting an understanding from my lawyer.
So tell me, what's an example? I don't want you to tell me what your lawyers told you, but I'm curious what it is you don't understand. You're charged with not stopping when the police tried to stop you, and you allegedly drove over a sidewalk, cut through oncoming traffic. It was all spelled out in the indictment. Made an illegal U-turn, sped away so you wouldn't be stopped, and your windows were too dark. So those seem pretty basic. I mean, it may be hard to remember because it was 6 years ago. That I get. Although it sounds pretty dramatic. My guess is you remember it. What's the part you feel like you don't understand?
I don't see all that going happening on what you said, but I haven't seen none of the report either, though.
Okay. Meaning you feel like you haven't had a chance to look at the discovery.
Yes, sir.
Okay. Is this a case, Ms. Dilligard, with dash cam?
It's body cam.
So the high-speed chases you can't see, or the body cam is on in the car and you basically see a steering wheel and.
Actually, this,
Oh, I think it's just the body.
yeah, so,
Mm,
Mr. Hall is stopped. The officer goes to his window, takes his identification, and then he.
Speeds away.
Yeah, so it's on body cam.
The speeding away part, but like the going over the sidewalk and the illegal U-turn. Okay. But tell me, so I want to hear you out, but you're coming in a little late to say, I'm gonna switch drivers. You have a good driver. And I was told when I chatted with your lawyer and the prosecutor that actually the two sides were pretty close in terms of resolving the case.
Yeah, we had some resolving the case, but I was open for resolving it, but I was trying to bargain with her or something, and she just said, well, we're going to take it to trial, and walked off on me.
Okay. Well, maybe the bargaining was done. And she got you the best deal she thought she could get you. What do you know about dash cam?
I'm still bringing it up right now. My computer's moving a little slow, but I did want to say that the resolution was a little intricate because this happened before the law changed. So it doesn't have that mandatory. So there was a or the year or the fine.
Right.
So we negotiated that he would do the fine instead.
And avoid the mandatory year in prison, because this was 6 years ago.
Right. And that he would only be reporting to felony probation misdemeanor probation on for 24 months of probation. And so we tried to get Gotham came and got it approved. And so she's been working really hard on his behalf. And
Got it.
That's kind of where we ended up. I would see there's a lot of moving parts.
So there's a felony disposition, but it's one of those peculiar fine only. There's no time, whether it's probation or prison or anything, it's nothing. And then it's 24 months misdemeanor probation. Okay. Thank you, Ms. Clark. So Mr. Hall, tell me what you want to do. I understand what the state's offer is. It strikes me as a reasonable offer, but I'm not the one who has to do the sentence. You are. It sounds like it's a misdemeanor probation plus this felony fine, and you're on your way. What is it you think a different attorney is going to be able to do?
Well, first I was going to take it, what she told me was 12 months, and then it switched over to 24 months.
Okay.
I guess for the extra year for the window tint or something, I was trying to see if she can run it like together. Or something like that.
Okay.
So I was trying to see.
Got it. So that's one change that a different lawyer, I guess, could argue for. It sounds like Ms. Wood was able to convince the state to pursue the fine rather than the mandatory year in jail for the felony count. That seems to me, again, not my case, like a bigger win, avoiding a year in jail than, was it 12 months probation or 24 months probation? And that may have been as far as the state wants to go. That don't matter who your lawyer is. If the state says, here's where we are, otherwise let's go to trial, then the jury can watch the videos and do this and that and decide what they think about it. And that may be what you want to do. That's we're back in 11 days for trial, and I'm good to go with that. And if you would like to have a different lawyer represent you for that trial, you're free to hire anyone you want between now and the 19th. That person just needs to be ready to go. Because what I wouldn't do is say, oh, you're new to the case. That's 6 years old, and I'm going to give you more time to get ready. So that's sort of where we are. I'm not saying no to can you bring someone in, but you need to act fast and I guess have the money to make that lawyer be interested in jumping in and trying the case. I don't want to discourage you. It's not a particularly complicated case, and so you may well be able to find a lawyer who said, it's a traffic case. I mean, it's a driving thing. It happens to have a felony piece, and so the lawyer might say, as long as let me just watch the video with you. All right, I see what we got. And he or she could say, you don't have a good case, but I'll represent you and fight it, and let's go to trial. Or it might look at it and say, you got a great case. That's not even you driving. Why are you being prosecuted? But it sounds like there's pretty clear video that you were driving, they have your ID, and then you drove away. It's kind of leaving some important evidence with the police. But do you want to talk with Ms. Wood a little bit more, or you're pretty certain, look, let's go to trial, judge, and if I can line an attorney up, I'll do that. But otherwise, Ms. Wood will be the attorney for me.
I talked to her.
You want to talk to her a little bit more? Okay. Ms. Wood, is this your last case for today?
Yes, sir.
Okay. Do you mind talking with Mr. Hall a little bit more?
No, sir.
Okay. And before you guys start talking, Ms. Dilligard, I heard Mr. Hall say, well, I was hoping maybe there'd be a little movement on that misdemeanor probation as well. Did I hear you correctly that it's 24 months, so 12 plus 12, not 2 12s concurrently, and that was part of the intricate back and forth with you going all the way to a supervisor to see if you could go forward with a fine rather than the year in prison. Okay, all right. So I think the DA's office has spoken, but why don't you talk with Ms. Wood? Maybe Ms. Rios will join. You can get 2 lawyers, and we'll see. I'll be right here. Sounds like she won't.
I had to go meet with Gabriel Reed in her office. That's why I stuck around.
Oh. Okay.
Disposition for hearing consignment. So according to how
So he doesn't have to what? Oh, okay. I'll do that. All right, I'm gonna go back and sign a couple things, so they're processed in time. And hopefully we don't have a staff member with tuberculosis.
receiving that.
And I'll be right back out. So I'll mute things out here. We'll see if we got one more plea. There we go. All right. Madam Court Reporter, you got one more plea in you? She does. Look at that. She's raring to go. Let's make it 2. No. All right. This is position 1 on our trial calendar, our oldest case, and it's even older than it looks because it's from 2019. We have Brian Hall in front of us, 22 SC 182123. He's represented by Ms. Wood. Ms. Dilligard represents the state. You sat through a few of these pleas already today, so you know what's going to happen. You get sworn in, you answer a bunch of questions. You let me know if you have any questions, and we see where we get. Got it? Who's in court here with you today?
Ms. Woods?
No, in the back.
Oh, that's my girl.
Your girl. Okay. All right. Let's get going.
Can you please raise your right hand? Do you swear or affirm that the statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can lower your hand. Please state your true, correct legal name for the record.
Just say your legal name for the
Oh,
record.
Brian Hall.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you've not taken today?
No.
How old are you and how far have you gone in school?
34 and I'm in college right now.
You're in college right now?
Yes.
Where are you going?
Chattanooga State
Chattanooga State. In person or online?
in person.
All right. That's in Chattanooga?
Mm-hmm.
Okay. Where are you studying?
Industrial automation and robotics.
All right. Is that a 4-year program?
No, it's just one.
1-year program. Okay.
Do you understand that you've been charged with the following offenses? 1 count of felony, fleeing and attempting to elude, reckless driving, and driving window tint violation.
Yes.
And do you understand that you have the right to plead either guilty or not guilty to those charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer about the charges in this indictment, including the facts and circumstances related to the charges?
Yes.
Do you need any more time to discuss the case with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes.
Counsel, do you waive formal reading of the indictment and waive any and all defects for purposes of the plea?
We do.
And Mr. Hall, do you remember have been arrested for these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for which you're pleading guilty to today? It was still 1 to 10 back then too, right?
Thanks. 1 to 5.
1 to 5. Okay. So for count 1, it's 1 to 5 years. For counts 2 and 3, it's 1 day to 12 months.
Yes.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the recommendation is, the sentence is 24 months probation, 40 hours of community service, the TVIP traffic violators impact program, and the $5,000 fine.
And the $5,000 fine is the sentence for count 1.
Correct.
Okay. There's not a custodial part or a probation part because back in 2019, it was an or.
Correct.
Okay.
Judge, if I may interject, because I don't want him to freak out. Just in all of our negotiations, I neglected to get all of those special conditions down. My apologies.
Okay.
So could you say those one more time?
Yeah. So it's 40 hours of community service and the TVIP.
And that's the traffic.
Traffic violators
Right.
impact program.
Right.
Do you gotta come here for that?
And I think it's a online program.
It's probably online. You certainly don't have to come to the courthouse. The folks on misdemeanor probation will let you know whether it is something you can watch or if it's you go to a class or something.
Okay.
Okay.
Okay. So do you understand that that's the recommendation that the state is offering to the court?
Yes.
And do you understand that the court is not required to accept the state's recommended sentence?
Yeah.
And do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yeah.
Do you understand if there are multiple charges which you're pleading guilty to today, that the court also has the right to run those sentences consecutively?
Yes.
Do you understand that if the court decides to order a sentence that differs from the plea, you are expecting that you have the right to withdraw your plea of guilty?
Yes.
Can you speak up just a little bit into the microphone? Are you currently on probation or parole anywhere?
No.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Using first offender?
Yes.
Okay. Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty to a felony in the state of Georgia?
No.
Have you ever pled guilty to a felony in any other jurisdiction?
No.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
No.
Do you understand, or has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, that your first offender status can be revoked?
Yes.
This means that you can be adjudicated guilty and can be resentenced up to the maximum sentence for each charge in this indictment. Do you understand?
Yes.
You understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses.
Yes.
And do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial.
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Mr. Hall, how do you plead to the charges of driving, fleeing, and attempting to elude, reckless driving, and driving window tint violation in indictment number 22 SC 182123?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
And do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
And do you understand that for a felony charge, you only have 4 years, and for a misdemeanor charge, you have 12 months from today to file that petition?
Yes.
Judge, in this case, were to proceed to trial, the state contends that the evidence will show that on June 2nd of 2019, officers with APD initiated a traffic stop on Howe Mill Road for a window tint violation. After the vehicle stopped in the parking lot, officers tested the window and found illegal light transmission of 15%. The driver was identified based off of his license that was provided to officers as his defendant, Mr. Hall. Officers noted that Hall had an active warrant out of Tennessee for a simple assault. Officers asked Mr. Hall to then exit the vehicle. He then fled away at a high rate of speed, leaving drag marked and driving his vehicle over the sidewalk. He cut across the southbound lane and made an illegal U-turn and continued at a high rate of speed until he escaped the officer's view.
Got away.
He got away, but they were able to track him down because he left a pretty key piece of evidence with them. So.
All right. But that also explains some of this gap of it was in 2019 and the arrest isn't until later, and
yes.
Not why it took so long to get to today, but at least some of it. Okay. Got it. Ms. Jackson, do you have criminal history information for Mr. Hall? Sounds like there may be something up in Tennessee.
Yes, Your Honor. He has 9 cycles. The last arrest was February the 1st, 2022, out of Tennessee for, it looks like it was a probation violation for a traffic offense. He does have misdemeanor convictions. There is one in 2022 out of Catoosa County, Georgia, for obstructing or hindering a person from making an emergency telephone call and simple battery. And there was one in 2010 out of Tennessee for driving without a valid license and misdemeanor possession of controlled substance. Nothing in addition.
Thank you so much. And thank you for being on the call today. We will catch up with you another day.
Thank you. Have a great day, Your Honor.
You too. Ms. Wood.
Thank you, Judge. I'm asking if the court will consider waiving probation fees so we can focus on putting his money towards the $5,000 fine. Also, we are asking for first-offender treatment on this case. And finally, I have had mixed results with misdemeanor probation clients with the call-in reporting since he lives in Chattanooga. He wanted to ask if the court would consider just noting somewhere in the final disposition that that is acceptable since he lives out of state.
The mixed results meaning sometimes they say it's okay and sometimes they say no.
Well, I've had at least one client or misdemeanor probation has told me like I need the judge to say that it's okay.
Okay.
For call-in reporting.
All right.
And I will get all of his information to misdemeanor probation.
Okay. And home is in Chattanooga or is it in Catoosa County?
Chattanooga.
Okay. How long have you lived there?
All my life.
Your whole life?
Yeah.
What were you doing down in Atlanta in June of 2019 on Howell Mill?
I was headed to the studio.
What were you doing in the studio?
I was getting some music mixed,
Okay. As in you were mixing it or you had someone mixing it for you?
having a mix.
Okay. You're not on probation now for anything out of Tennessee?
Oh.
That's closed, whatever it was?
Mm.
Okay. All right. You have any questions?
No.
Are you working along with being a student at Chattanooga State?
No, I'm full-time in school right now. Monday
So you're
through
missing
Friday.
class today?
Right now, we out to the 12th. We went from spring, so we starting our summer semester Monday on the 12th.
Oh, so this is where we're catching you during break.
Catch me on break.
All right.
10-day break.
So you're 34, full-time student, that mom and dad putting food on the table for you? Or how is it that you're eating and whatnot?
Nah, with me and my girl, we got a business.
And what's that business?
Clothing line, and we got a shop, and she do lashes and stuff.
That's what she does at the shop?
Yeah.
Okay. And there's also a
Clothes
clothing
and
line.
stuff. Yeah, we're selling clothes and stuff.
Are you wearing any of the clothes from the clothing line?
Nah.
They're too good for you or?
Most for women.
Oh, women's clothes. Okay. Well, hey, you should wear what you want to wear. But today you're not wearing those clothes. That's all right. Well, Mr. Hall, I find there's a factual basis for your plea. I'm sorry, and I mean this sincerely. I mean, what you did was stupid and dangerous, but you shouldn't have to wait 6 years to deal with this. It would have been a whole lot more impactful. It's not anyone in this room's fault, but if we were together in 2020, and if I'm fussing at you, like, you dummy, you're doing this running from the police and it's dangerous and a U-turn. And I know Howell Mill, that's a crowded place. You could have hurt someone, you could hurt yourself. But I mean, 6 years have gone by and you haven't done anything too crazy since then. So it shouldn't take this long, but it did. And I think this is a reasonable outcome. The state wasn't saying lock them up. I bet if you had done this a few more times since then, they might. But I do find there's a factual basis and that your plea is knowing and voluntary. No one's forcing you to enter this plea. You told me you have no more questions. Ms. Wood, can someone in the office sign for you the indictment?
Yes, Judge.
Ms. Dilligard?
Yes, Judge.
And Mr. Hall, we can electronically sign it for you?
Yes.
Great, we'll do that. Do you have a weapons carry license?
No.
Okay. First offender, it seems like you want to be sentenced as a first offender. Tell me why you want to do that.
Say why? I ain't been in trouble in Georgia, but I'm not really from down here though.
Okay, but first offender means that this won't show up as a conviction on your record. So if you're trying to stay at Chattanooga State or do anything where they might ask you, are you a convicted felon? You can say, no, I'm not, because a first offender probationer, and you're not even gonna be on felony probation, you just gotta pay that fine. How's that gonna work? Oh, we have to do a funky disposition.
I know it's possible. I just can't remember the steps.
Yeah, we had to map it out. And I'm assuming you don't have $5,000 on you well, these clothes are fancy. Do you have $5,000 on you? No? You're gonna have to come back. Not today, we'll figure out a time. But for this to work, we do this funny thing where I sign your sentence, but then your lawyer and you go down to the clerk's office, give someone the $5,000, and I think it lists the different ways they'll take it. Like they don't want it in Bitcoin.
Is it possible to loop it in through misdemeanor probation or not?
No, because it's a fine. It's not restitution. And so it's paid, I don't think so. We can ask. But I also wouldn't want them to say, well, because we're collecting it, there's a 10% surcharge or something. The fine is the fine. But we used to get these out of non-complex where that's all it was. Here we've got a probation piece, so there may be a way to do what you've said. But if it was just count one and it was just the fine, the judge would sign it and then the guy like, sweet, you have no way to enforce this. There's nothing left on my sentence. And so the judge actually wouldn't sign it and you'd go down with an unsigned final disposition, $5,000, bring back to me, here's the receipt from the treasurer, we received $5,000, and then I sign it and he's good to go. We won't do that today, but I need to ask some questions about how we make it happen. So you may need to come back here with the $5,000.
So I need to have it all at one time?
Maybe. It also may be that you can pay it bit by bit through probation. If that's how we're doing it, you're gonna need to have paid it off in the first year. And if you have it paid off in the first year, I'm happy to close out your probation. Okay? So let me pronounce your sentence. Oh, for first offender. I will sentence you as a first offender. Count one, your sentence is a $5,000 fine. That's it. Count two is 12 months probation. Count three is 12 months probation. They're going to run consecutive. So it's 24 months probation. And you have two conditions of the probation. One is the 40 hours of community service. And the second is to complete this traffic violators impact program. Which hopefully is online because now I get it why he's saying, do I have to come back here? You didn't mean come back to the court. You meant come back to Atlanta. Hopefully it's online and we'll figure that out. If you take care of your fine and those two conditions, community service and the TVIP program, within the first year, you can have your probation end halfway through at the 12-month mark. If you don't, I'm going to need to know from probation where you are 12 months in on paying that $5,000 because I'm happy to turn it into community service, giving you a little above minimum wage and turning each dollar into hours that you have to do community service, which I'm assuming you'd rather pay than more and more and more community service. But we'll figure that out. I'm hopeful with you becoming a robotics expert and the clothing line and all the other stuff, you'll be able to pay that off. Any questions?
No. With community service, I have to come to Atlanta?
No. What you need to do is document it though. So I'm making it up, but there may be a soup kitchen or a food pantry at a church near you in Chattanooga. And if you go there and they keep track of it and say, hey, Hall was here for 8 hours today, and you get a receipt from them signed by Reverend so-and-so, that's 8 of the 40 hours. And then you just get that, you scan it in and send it to probation. And they'll see it needs to be legit, not you wrote it on binder paper. It's like, hey man, I picked up garbage in the park for a little while. But it's on letterhead or something from the organization where you did the community service.
All right.
Okay? You really don't want to come back down here. All right. Ms. Dilligard, anything else?
Nothing further, Judge.
So I'm not going to sign the final disposition today. We'll need to figure out how to do this fine, whether you have to come back here with it all at once, and Ms. Wood will let me know it's going to take a few weeks, or if you can pay it bit by bit through probation. We'll figure that out. Anything else?
No, that's all.
Are you heading back tonight, or are you going to spend the night here?
No, I'm heading back.
All right. Does not want to be in Atlanta. I could add that as a condition. I'm sure the officers would appreciate it. That's it. All right. Thank you, everyone.
Yeah. All right, you're free to go.
Probation.
No, so what happens with missing probation? I give all your.
Thank you, court reporter.
Thank you.
I think I see you tomorrow too, so we'll pick up tomorrow with the motions hearing.
So just be on the lookout.
Yes, Judge, thank you.
All
right, see you then.
Judge, I know you're having a meeting, regarding to.
Yes.
I have a question in regards to, related to that.
Hold on one second. Let me close this.